Assignment C.
Pardon. Item 47. Value taken 2 weeks after. The similar matter posted to 14/5/2024.
P5.
I pardon, make a mention, my lords. This is a fresh admission CRLMC, my lords. The daughter, my lords. I have mentioned the matter last week, my lords. If it can be this week, my lords.
May I please your lordship? Your lordship, this is the matter which was
Yes, sir, that's
and yes,
entry model
yes,
continue one.
yes, my lord.
Entry model to continue.
That item 1.
Yes, yes. They
On that day,
the interim order was to continue.
Minor.
In the order sheet, it seems it
Inadvertently
found mentioned.
not reflected.
till 9/4. Till 9/4.
So therefore, till the next date appearing, the interim continue.
Other to 9/4.
Minor.
Item 2.
Deeply.
For that purpose only the matter was there today, my lord.
That was the only.
That is the only.
Item 2.
He mentioned the other day. Mr. Mishra, he had mentioned the other day.
My lord. Obliged, my lord. No problem. Obliged.
Yes, Mr. Mishra, Lalit.
Here, my lord, the case instituted against the present petitioners and the present petitioners, my lord, the
You are
office-
talking about item 2?
3.
item 2.
No.
No, 2 is my.
2 matter another matter.
No, you are in 3. Wait. Item 2. Wait.
Yes, madam. Another matter 2, the questioning of the cognizance order notice has been issued to the opposite party.
Receive.
And
First,
You are referring?
yes, your lordship. Today,
What was the matter?
they filed that petition for passing of the cognizance.
party
They
never
fine.
sought to joint affidavit.
Both party will come.
Okay, settle.
Compromise.
Yes, in between the matter has been compromised.
Okay.
Your lordship,
When can you bring
1 week after your lordship.
short date?
छुट्टी अच्छी तो होली फुल छुट्टी पर ठीक है आसु 1 week after so that will file joint affidavit.
Second. Bring them, huh?
Interim order for
Entry model.
Oblige.
Pardon to mention your lordship, my name reflected on yours.
Your name will be there. Don't be.
item 35, madam. Place and taken up.
Item 3.
Yes, my lord. I may be excused, my lord. I am sorry. Item 3, my lord. I am appearing to BC. I may be allowed, my lord. Here, my lord,
Yes.
the petitioners are the, my lord, officials of Tata Power, my lord, Northern Odisha. My lord, there are 4 petitioners. My lord, one is the manager enforcement, and my lord, second petitioner is my lord, manager enforcement, and other search also, my lord. They conducted a my lord, search. Kindly see page 35. My lord.
Yes.
Page 35, my lord, annexure 2, where
Yes.
my lord kindly see the premises of the my lord, petitioner, that is the my lord, Bharat Swai, the service station. Kindly see the last line, enforcement, they are MRTB squad, they have my lord, conducted the my lord, there is the allegation of theft and such, so sir. This premise with due permission, not the handwriting last portion, kindly see. With due permission, the said premises is verified and observed that the following. You lordship got it?
Yes, tell me.
Yes. The meter number so and so was installed. You lordship got it?
Yes.
Installed at the front side wall of the unit with box. 2.
Okay.
There is no box seal present in the meter box. 3. The meter terminal cover seals number so and so found tampered. 4. The meter box seal so and so found blood. 5th. The main body so and so. 6th. Blood is important. This is a clear case of meter tampering and obstructing energy by so and so. And where the opposite party number 2, my lord, informant who has filed a complaint case, he has signed. My lord, kindly see the bottom portion, Raj Kishore Swai, and he has given the number.
This is dated?
This is dated, my lord, 18/6/2022. 18/6/2022, my lord, the premises was inspected and the opposite party number 2, my lord, the complainant, informant, was present very much there and also signed the document. Thereafter, my lord, kindly see.
Yes.
Thereafter, my lord, a notice was issued on 6/7/2022, Annexure 3 series, page 36, my lord, kindly glance. That the provisional assessment was made as per, my lord, statutory provisions 126 and 126. Then, my lord, kindly see, the assessment was made and the date is very important, my lord. Kindly see Annexure 4. 4, my lord. I draw your lordship's kind attention.
Yes.
Annexure 4, page 39, my lord.
Yes, yes.
This is the grievance of the, my lord, complainant informant, opposite party number 2, where he, my lord, stated that so and so, the letter, no, 1, 2, 3, 4, 5 grievances he has mentioned. Never complained about anything about excess of duty or any kind of harassment or anything. He has, my lord, filed a grievance petition 1/8/2022. That is very important.
Right.
Occurrence,
Yes.
the inspection was made on 18 June. Assessment was made. He was supplied, my lord, served with the, my lord, the demand notice and, my lord, to pay the amount and all that. And also he filed a grievance petition on 1/8/2002. My lord, interestingly, kindly see, he filed a complaint, my lord, on 16/8. But after 3 months without, and the important allegation, what it is, page 33. Page 33, my lord.
What was the
Page
allegation
33.
here?
Allegation, can you see 33? This is the with regard to the, my lord, duty.
Come to relevant part.
My lord, B, that in the aforesaid facts and circumstances, it is crystal clear that the accused persons has knowingly and deliberately broken running meter of the complainant with the intention to collect money through fraudulent manner and for their personal
Where are
benefit
you
and
reading,
gain.
sir? Where are you reading?
Page 33. Page 33.
Okay. Yes.
That
I'm
is the
there.
complaint petition. Annexure 1, that is the relevant page 33B.
Yes.
That is B, my lord.
Exactly clear. The accused persons
B.
have knowingly and deliberately broken and running the meters also. Thereafter, what happened?
Thereafter, my lord, the complaint case was filed, cognizance was taken. So I am before lordship that the persons are protected under section 197. So I humbly pray that in the similar situations also, this honorable court has protected the same TPD officials in Sierra
I'll
Leone
say
number.
I'll say the proceeding. What is this?
That is criminal proceeding.
18/6/2022, the raid takes place. And 6/7/2022, the assessment was given. And
Everything
he
was
gives, the informant gives a report
Aye.
on
One-
1/8/2022. She doesn't say anything.
no.
And after just 10 days,
Please.
then he gives complaint saying that this happened.
That is my grievance.
Notice may be issued to everybody.
Issue notice.
And I have a complaint case.
Issue notice to the opposite
Two.
party number 2, and Mr. Ragala accept notice for state opposite party number 2, 1. I read it. Mr. Lalit Mishra had taken me to the court to argue that on 18/6/2022, while Annexure 2, the inspection was conducted, and it conducted by the petitioner, being the employee of
TPNODL, Tata Power Northern Odisha Distribution Limited. ODL.
TTONDL, and various objections were raised by them to suggest that there is a theft of electricity. There is a theft of electricity.
And the OP number 2 being present, Lord,
And
obey.
the said inspection was signed by the said inspection was made in the presence of the opposite party number 2. Thereafter, an assessment was made on 6/7/2022, 6/7/2022, raising the 6/7/2022. What is this? This is the electrical due, the
My lord, that is a theft of electricity and due is there 2,12,000.
electricity due was shown to be 201233.20. Dot 20.
As per provisional assessment under section
In
126.
the informant, the opposite party number 2, on 1/8/2022, 1/8/2022, by the next 4, gave a representation to the executive engineer of the company, inter alia, making certain regarding the electricity due, However, in the state grievance letter, not a single there was not a single whisper regarding any misconduct of the raiding party on 18/6/2020. However, on 16/8/2022, the opposite party number 2 filed a complaint, being ICC number 461/2022, before JMFC Jajpur Road, making various allegations, so as to attract the commission of offence under section 323/295/465/468/469 IPC. The letter court below has taken upon. Therefore, the petition is rejected. Agree. Therefore, the petition is agree. Next further. And the issue notice in the meantime, the proceeding in ICC case number 461/2022, pending before JMFC Jajpur Road is stayed.
Grateful, my lord. Obliged.
Yes. Item 4. Yes.
May it please, Your Lordship. My lord, this is the case where the present petitioner is challenging the entire criminal proceeding that has been initiated. On the last occasion, Your Lordship, if Your Lordship may kindly have a glance at this order, the coordinate bench of this honorable court directed the matter to be stayed till a particular date, but the matter was not listed after that, hence the stay was vacated.
Provided, what is this order?
My lord, this is the order,
Stated, same matter,
my lord,
2402.
my lord. Well, in this case, my lord, the allegations were
It is
initially,
not there, what?
my lord,
This is dated 25/7.
my lord.
25/7. It is there with me. Why are you giving?
Well,
I don't-
I just made it convenient for
Anyway,
Your Lordship.
what do you want to show here?
My lord, initially the allegations were under section 498A, 302, 304B, 34 read with section 4 of the Dowry Prohibition Act. Subsequently, charge sheet was submitted under section 498A and 306. My lord, the basic allegation against the present petitioner is nothing but only one thing, that the present petitioner questioned his wife as to where she has transferred rupees 51,000, and that is very much pertinent from the bail order. It has been clearly mentioned,
Should I read that part?
my lord, if Your Lordship may kind,
To find the person of the Yes, further proceeding is state, because see, the charge has already been framed.
my lord, further proceeding was stayed till 25(8).
That's right, but since charges have been framed,
My lord.
what to do? Have you challenged the charge?
My lord, I have challenged the entire
What you are
proceeding.
saying is, ultimately, what you are saying is may be correct in the sense, 306 is not made out.
My lord.
98 may be made out. May
My
be
lord.
made out. So you are attacking the charge itself,
My lord.
isn't it?
My lord.
So if the charge is framed, why have you not challenged that charge? You allowed the charge order to hold the field and allow the evidence to go on.
My lord,
And
no.
now you are coming and asking that you quash everything.
But my lord, not a single piece of evidence has come out because nobody has been examined till date.
That's right, but why have you not challenged the charge? I am wondering.
So I challenged the entire initiation of the criminal proceeding against me. That was my. Because if a lordship may kindly have a glance at the allegation, because the allegation is merely on one fact that why did I transfer 51,000?
You are absolutely correct.
My lord.
But the due process has to be followed.
My lord.
Process of law. What to do?
Absolutely, my lord. But
Yes, Mr.
He has filed a revision, well, actually. And he has not filed any petition before the trial court at the time of framing charge. Petition not filed.
admittedly not.
Straight away, my lord, come here and fight that.
Admittedly, we have not done.
That's the difficulty.
My
You
lord.
have not opposed, you have not argued,
My lord.
and all of a sudden you want that everything should be
My lord.
washed away. So that
My lord.
And whether the
when the charge was framed?
My lord, the charge was framed.
On 25/3/2022.
Must have been, my lord, the trial has already been progressed.
No, you see the order, if you see the order 25/7/2023,
My lord.
it says the para 4, it says the metro was charge was framed, metro was fixed on many days.
My lord.
No PW was present.
Nobody.
Now, my lord, what happened?
Till date also no PW has come up.
Thereafter it was stayed by this court.
My lord,
My lord.
So PWs are not
my
examined.
lord.
The fact remains that the charge is staring on the face of record. And he has a case, then what to do?
My lord, since they made the informant as a party, my lord, I think notice would have to go to the informant. Yeah? As because he made state is a party, no doubt, my lord. State is the necessary party. But in fact, they made the informant as a party too.
What we can do is, I'll tell you, to overcome the technicality, what we can do is, since the trial has already been stayed by this court,
My lord.
and he has to challenge that order of framing of charge, let him challenge it.
My lord,
And
in the division.
till he challenges, the stay should
My lord,
continue.
that will be applicable.
And continue in the revisional court will see
My lord.
whether stay should be granted or not. Okay?
Good.
What I'll do is, I'll allow you to file a revision
My lord.
challenging the charge.
My lord.
Okay, till then, the stay granted by this court will continue.
Will continue. Grateful.
And persuade that court if no charge is made out. No charge is made out.
Absolutely.
So it is a balancing act. Okay?
My lord.
Right now. The grievance of the petitioner is that even if the material available on record is taken at its face value, no offense under section 306 is made out against him. Next paragraph. The matter was heard by the coordinate bench on 25/7/2023. It was pointed out by the counsel for the state that charges has already been framed by the court below on 25/3/2022 under section 498A and 306 and allied provisions. Therefore, the fact remains that the charges has already been framed, and the petitioner has not challenged the charges. Charges framed against him. The coordinate bench on 25/7/2023 has stayed the proceeding pending before pending before the court below in the ST case number 220 of 2020. Therefore, even though the charge has been framed, but the trial has not commenced. Yes. At this stage, the legal counsel for the petitioner submits that he would avail the remedy challenging the order dated 25/3/2022 by which charge under section 306 IPC has been, framed because apart from the other charge. However, he submits that the proceedings which has been stayed by the coordinate bench on 25/7/2023 may continue till he awaits the remedy challenging the order of framing charge. It is definitely next on the foregoing, the petition is disposed of. Petition is withdrawn with the liberty to the petitioner to challenge the order of charge in the under due process of law till then, till he files the revision petition. The interim order passed by the coordinate bench on 25/7/2023 shall remain in force.
One amendment, he will not file the.
Till he files.
Otherwise, he will.
And the council.
Time.
Your lordship may fix the time.
He would be filing the revision petition within 15 days.
Yes.
Within 15 days you file.
Lordship
then
may
you can
kindly extend me 1 month at least.
I'll
see-
22nd. I'm giving. Otherwise, I would have dismissed 22nd. The charge is framed.
Malad.
Till I'm giving 15 days, you go and file it
Malad.
immediately. Because you got a stay, therefore, this is operating since July 23.
My lord.
So you get little more. Make it 20 days. Make it 20 days.
Grateful. Deeply obliged.
Yes.
Item 5.
Yes.
May I please your lordship?
Yes, madam.
My lord, here in this case, the present petitioner filing this application for quashing of the FIR and the proceedings in GR case number 700 of 2012, my
What
lord.
is the stage of investigation?
My lord, final form not yet produced, my lord.
Wait,
Fine.
wait.
My lord,
Why are you so hurried? They are still
I think-
investigating.
What happened in this case, my lord? I have gone through the petition, my lord.
Mhm.
In the year 2022, 12, my lord. FIR lodged by the.
For a 20
Then Tahsildar, who is an IS officer, my lord. Her husband also an IPS officer, my lord. By the
And
time.
the investigation is still going on.
And what happened in this case, my lord? There are settlement, my lord, between the all petitions are lawyers of Sambalpur Bar Association. 2012, my lord. For that, there is settlement, my lord. And now what happened, my lord? This said Tahsildar, my lord, suffering from cancer, he treated at abroad, my lord. And for that reason, my lord, if the notice will issued, this will appear, my lord. Settlement,
Investigation is still going on.
my lord, not, my lord, confident.
What is this
Madam.
2012 and
Next date also, I will take further instruction. But so far my knowledge, my lord, the.
and what about the yes,
Since-
they are on bail, all of them.
All of them, my lord.
all of them on bail.
My lord.
But I think this is high time that we should quash it.
My lord, but the exact, my lord, notice may be issued, my lord, for so that, my lord.
See, first of all, lawyers are involved.
My lord,
Second, the Tahsildar is suffering from cancer.
my lord.
And third is in 2012 the FIR is registered.
My lord,
He did not
and
appreciate
that-
for 3 ground to
my lord,
pass the entire thing.
my lord, page 21, my lord.
Matter is set.
Minutes, my lord, meeting held under the chairmanship of RDC and others, my lord. Sambalpur Bar Association, others, my lord. They have settled, they have decided to settle this dispute, my lord. For that reason, cases.
But see, settling and everything is
Madam.
a separate thing. But what the police was doing?
My lord. For that reason, my lord, the police. Not proceeding, my lord, since lawyers are there. For that reason.
What else is there? You get the CD, whatever is there,
My lord.
we will quash it.
And also notice,
Notice, I'll issue notice, get the CD
my lord.
and remind me so that
If informal particularly appear, my
the
lord.
lawyers are there, why
My-
should unnecessary?
My lord.
I'll quash it. And give a short date. Next, first week in deals. First week. Fifth, issue notice to, fifth, issue notice to the opposite party. How many
So all are lawyers.
lawyers? All of them are protected?
My lord,
Protected? If you want protection also, I can give now. You tell me. If anybody is not protected, I can ask for no court case.
my lord,
But-
all of,
Sure.
my lord, interim protection may kindly grant. If there is,
Issue notice to the opposite party number 2, Mr. Goda, kept notice. Yeah, notice. the petitioners are seeking quashing of the entire criminal prosecution against the criminal prosecution initiated against them at the instance of opposite party number 2. Opposite party. The FIR is pertaining to the year 2012. Surprisingly, although more than a decade has already lapsed, investigation is still continuing. It is stated at the bar that the informant, with the Tahsildar, has been suffering from terminal disease and under treatment. Under treatment overseas. The petitioners are the practicing lawyers. In this scenario, Mr. Zagada who seek instruction regarding the status of the investigation and produce the CD before this court. The CD of the case before this court on the next day.
And also progress of the investigation.
And progress of. Okay. We'll quash it unnecessary. No point. Yes.
Obliged.
Item 6. Yes.
May I please, Your Lordship?
I am appearing for the opposite party number 2. In the meantime, matter has been compromised between the parties.
When are you bringing them? Today? Bring them tomorrow. We'll quash it.
And on good 7 days.
307.
307 allegation, injury simple.
Medical
Injury simple in
simple. Bring them tomorrow day after 1 year.
Yes.
27 Your Lordship.
27. Okay.
This one I will find.
Take
Copy to.
Mr. Das intercepted this opposite party number 2 and file affidavit of the opposite party number 2. The parties have settled the dispute. Is the matter on 27.
Item 7. My lord, on behalf of S.K. Mishra, my lord, one pass over.
Pass.
Item 8.
Yes.
This case, your lordship had directed their personal appearance. They have
They are
come.
there.
Yes.
Bring them. We'll quash them.
Two cases are filed, one by the lady, the informant, and another by the accused. my lord.
Okay.
The lady has filed, the informant has filed the case because
First one is filed by.
the accused. Accused. my lord.
Okay.
Sec-
Sure.
The next case is by the my lord, informant, because she has already married in the meantime, of course, to a different person, and she has been blessed with a male child, my lord. Now, if the case proceeds,
No,
it
no,
will-
we'll quash it. That's not.
Yes.
What is the allegation?
the allegation is, my lord, there was love affair between both, my lord, and this
417, 493, 313, 506.
493 was initially booked, my lord.
Okay.
Thereafter, it
All
was,
right. What about the other case?
my lord, the other case is filed by the
What are
informant.
the offenses?
Same
upon.
arising out of the same case.
Why?
The
One affair.
All right.
one.
Right on. Common order we will write or what? Common.
Yes,
Yes,
my
my
lord.
lord.
Common order.
Common order.
The first of the 393 of 24. I would have the first of the 1454. no? Sorry. 393 is first one and 1454 is second. The effort next one. The aforementioned two criminal misdemeanor named criminal MCA case are arising out of the FIR number so and so. Both the cases are cross cases.
Then cross same case, ma'am.
And both the
One-
cases
one
are filed by the parties interested against each other.
For quashing of the proceeding. For quashing of the proceeding.
FIRs are cross cases. No, FIRs are cross cases.
No, my lord. One FIR. The informant has lost the FIR, my lord. The informant in that 1454 High Court of 2022 has been filed by the informant for quashing of the proceeding. That FIR.
Same FIR, but two separate petitions.
Two separate petitions, my lord,
FIR
filed.
is same.
Yes, my lord.
Okay.
Informant does not want to
Okay.
prove. Yes.
Both the CRLMC
Arising out of.
filed by the petitioner are arising out regarding quashing of the FIR number 4.
6 of 2008.
At the instance of opposite party number 2 in CRLMC number 393 of 2024, the FIR was FIR in subject was registered against the petitioner. Next one. In CRLMC 1454 of 2022, the petitioner is informant and opposite party number 2 is the accused. Will be said about. Next one. The parties have now settled their dispute. Both the parties, petitioner and opposite party are present in the court. They are represented by their counsel and identified by them. They filed the self-attested copies of their Aadhaar cards, which are taken on record, which establish their identity. The parties have filed the affidavit inter alia stating that
No, affidavit separately file करनी.
parties
Because-
are appearing in person in the court and inter alia states that they have settled their issue. The opposite party number 2, Kunni
Kunni Kradika.
Radhika,
Alias Kunni Gagaranga.
Radhika states that she has settled her life. She has married whom?
No,
Married to
Jakya did.
no. Jakya is
Oh, another second husband.
No, second husband no. से जणों को marriage करी
हाँ,
थी.
कौन तो?
मतलब ताकि ना कौन को? तम husband का ना कौन को? हैं? तम husband को ना.
Let it come next.
You have settled very true.
Yeah.
Well, the matter
What
is
that
settled.
instruction I have. So we'll file a
When
2 तारीख पर आसु.
do it settled, these two settled.
Yeah.
And the so and so appears for the appear for the opposite parties on advance notice. I submit that the parties have settled the dispute, and on the next date of hearing, both the parties will be appearing in the court. Leave the matter on second, third,
Yes.
third, fifth.
Yes.
Right.
Published.
Okay.
Item 11.
May I please, my lord, on behalf of Mr. S.K. Trivedi, kindly pass over.
Item 12.
Yeah, please.
Yes.
Within the compromise between the parties, my lord, wife and husband.
Where are they?
In the common.
Okay. NBW was issued on 12/12/2022. How many of you are there? 500 each.
Yes.
And to appear before the court on 20th. 20th, on or before 20th. So, 20th. Yes. Next. 14.
14 में please. This is same thing, my lord.
Yeah.
Belgium.
Bail, when
bail-
you got the bail, do you have the date?
Well, my lord. 28/8/2018, my lord.
28/8/2008, the petitioner was admitted to bail due to default in appearance 28/3/2023. The NBW, then Piro and 500. Hello. Item 15.
May I please also? At the Belgium matter, my lord, petitioner written bail on 21/1/2017.
1/1/2017.
My lord.
Bail, NBW issued
From
on
26/9/2022. 26/9/2022.
which item you are talking about?
The 15, my lord.
15.
My lord.
So
Yes, 17. My lord, yes, my lord.
26/9/2022.
Alert.
ठीक है, NBW. 500.
Obliged, my lord.
Item 16.
May I please yours? Lordship, on behalf of B.R. Dalai, the Belgium matter, my lord. The petitioner of religion bill 10/8/2022 and date of NBW is 9/8/2022.
NBW 9/8/2023. 500. Item 18. 17. Item 17.
17 may be lordship. The Belgium matter, lordship, the petition earlier on bill in the year 2021 by the code below. And the individual is
Date, give the date.
the gate, lordship,
He was on bail, huh? Was on bail.
it was on bail, lordship. And the individual issued on 17/11/2022.
17/11/2020. NBW. कितना ऑप्शन थी? 500.
Obliged.
Yes. Item 18.
18 is also Belgium matter, lordship, the earlier on bill 25/10/2021. And the individual issued on 6/9/22.
500.
Obliged.
Item 19.
May I please your lordship? Belgium matter, my lord. Previous bail was on 13/2/2018 and NBW is issued on 26/5/2022, my lord.
500.
Please, my lord.
Item 20.
My lords, Belgium matters, NBW issue 31/8/2023, my lords. Earlier, 31/8/2023.
Bail.
Earlier he was on bail, my lords.
Tell me the date if you have. Do you have the date?
31st August 2020.
That I know, sir. Bail. When you got the bail? Do you have the bail? Right on bail.
My lords, he was earlier bail on 12/12/2017, my lord.
12/12/2017 bail. 31 after the NBW 500. Yes. 21.
May I please? Here, my lord, the petitioner has filed this criminal miscase seeking quashing of NBW.
Now tell me, you are on bail.
No, I am not on bail. I know no knowledge about this initiation of.
Sorry.
I have no knowledge regarding the initiation of this proceeding.
Now you got the knowledge. You go and appear now. NBW was issued on
tribal
28/9/2022. Let account for the petitioner. Let account for the petitioner submit that he had no knowledge regarding any case pending against him. However, he received however, he came to know regarding the issuance of NBW on 28/9/2000. Issued by which court? Issued by SDJM Birmadapur. Bir Maharajapur. In GR case number 137/2022. On instruction, which is appeal here on Puri appeal and seek remedy. Available to law. Till then, the NBW is kept in abeyance.
Only one thing, my lord, he is a tribal by magistrate. Without issuing 41 notice on the prayer of the IO before charge sheet.
I'm keeping it in abeyance. Go and tell all the things.
Yes.
So till 20th of April. Yes. 22.
Please, lordship. This is a Belgium matter, my lord. NBW issued, my lord, against order dated, my lord, 23/7/2029, my lords. And he was made appearance in sessions court, but not subsequently NBW issued, my lords.
When you got the bail?
Date was not.
You were on bail?
My lords. You were on bail, my lords.
NBW was issued on 23/7/2009.
9, my lords.
Where were you?
My lord, criminal revision. I have filed the criminal revision, my lord. That was stayed, my lord, and 2017 that was disposed of, my lords. But the Law and Counsel for the present petition are not contacted the present petition. Petition is a lady, my lords.
Let him appear before 20th and give 1,000. Let him appear on or before 20th April. Appear and seek remedy.
My lords. He was on bail, my lord. Already.
Whatever you seek remedy, go and tell. Appear on that stick before 20th April.
And released on bail, my lords.
You appear and apply for it. If you are on bail, you will get bail. If you are
Madam.
not bail,
Yes,
you will
ma'am.
not get.
Obliged.
23. Why this repetition?
23, my lord, on behalf of Mr. Das, my lord, kindly take on next week, my lord. Is out of
Why
station.
this repetition before me?
Because it was specifically assigned to this honorable bench because the earlier
Isn't
bench
it?
was concerned with this matter.
24.
My lord, I pray that I have filed an IA for intervention which is at flag B and they have also filed their
Intervention allowed.
they have filed the objection. The copy has not
Like
been
objection.
the copy has not been served on me.
Supply a copy.
My lord.
A specific
Supply a copy. 23rd simply, item 23 simply adjourn. We'll see.
My lord, I pray for a specific date because they have stayed.
Specific date will be given by this court. Don't worry.
Obliged,
You
my
will
lord.
get the specific date.
Item 24, one simple
23, my lord,
modification.
pardon, my lord, entry mode continue, my lord.
Yes, 24, what happened?
One modification, the order was kept to be kept in evidence till 29/2, but the certified copy could not reach Malkanagiri in 29th.
Where is that order?
That order I have annexed, sir,
Where is that?
annexed. Your lordship has passed the order and the NBW
Where-
was kept in evidence till 29.
Where is that?
Page 9, my lord.
9 up?
Page 9 of the
I. Interim application.
Where is that?
Page 9 of the interim application number 569 of
24, item 24.
My lord.
Yes. IA number 569 of 24.
569.
Yes.
My lord, order starts from my lord page.
Now, which is the I number?
IA number 569.
This is Kuni.
Nikhil, my lord, Nikhil
Nikhil
Chandra.
Chandra Tapoli.
क्या क्या है वो सर 24 क्या है निखिल चंद्र टपोलिया ठीक है when I open it something else is coming ये फाइल है can be something else some file huh?
Yes.
That is I was wondering where is that Justice Pujari passed some order.
Yes,
I
sir.
don't know. So which order you want extension?
Order dated 12/2/2024. Your lordship directed to appear before the court on 29/2/24, but the certified copy could not reach on that day.
Oh, this NBW, huh?
NBW was
Okay.
to be kept in evidence. So I pray for a modification for extension of time.
By the order dated 12/2/2024, the petitioner was given liberty to appear before the court below on or before 29/2/2024. And till then, the NBW issued against him was kept in evidence.
Yes.
By way of the present application, he seeks modification of the said order because he received the certified copy of the said order belatedly.
Yes.
The modification application is allowed, and the petitioner is granted liberty to appear before the court below on or before 20th of April.
20th of April. Yes.
20th of April.
Yes.
20 Malkanagiri, na?
Yes.
20th April or 25th of April. 25th of April 2024.
This is
and
March itself. This is March itself. So April will be far more. On or before, yes.
On or before?
Yes, yes. On or before.
So that you will not come.
Yes,
for
yes,
that
yes, yes, yes.
modification.
Yes, I could understand.
On or before. You go tomorrow, who
Yes.
stops you? And avail remedy under law.
Yes,
As directed by this court on 12/2/2020.
Yes.
Modification allowed. Yes.
25.
My lord, I am appearing for applicants.
Yes.
My lord, I am appearing for applicants.
You are appearing for?
Petitioner, sir, my lord.
Petitioner, yes. You are also appearing.
No.
For 10.
See other item.
I'm begging your pardon, madam. For 10, I am praying interim protection.
Notice it.
That's
Which
not-
one? Which?
He's happy.
She's saying item not 10.
Last
You say that interim protection is
No,
there.
my lord, no. In item 10, the matter which is settlement.
Or settlement.
My lord, that matter.
Item 10 settlement, since there is a settlement between the parties, proceeding before court, so court is stayed. Item 10. Settlement is it?
I get obliged.
My lord, this application
Why are
is
you getting wiser after leaving the court?
My lord,
You should be attentive in the court itself.
I
Immediately
noted-
you should think over.
I noted down, but I forgot, unfortunately.
Anything. That was, his mind is there in the election.
Thank you.
Yes, 25.
my lord, this application is for recall of NBW. Trial court.
Yes, you were on bail.
Yes, I was informed. We are on.
Give the date.
Sir, date of NBW is so 16.
NBW, I know. It is there. When you got the bail, you tell me.
Previously, I was on bail by the trial court.
Yes. He was on bail. NBW was issued on 16/3/2022. And 15 or not.
Three accused.
3 accused. 500 each.
Sir, my lord.
You have to pay cost 500 each.
Yes, my lord. Yes.
Okay.
Yes, my
26.
26 may I play lost in my lord. I have for extension of time, my lord.
What is the problem?
My lord, NBW is against the present petition on 19/6/2023. NBW issue, my lord.
26.
My lord, kindly be small.
Ojita Bacharya.
My lord.
NBW issued which date extension you want?
My lord, 2/8/23, my lord.
2/8/23. Considering the granted exemption from personal experience before the court, your absence in state. Also, I inclined to take beginning and view the imperial of the You didn't appear.
No, my lord.
Now you were asked to appear on the next date of meetings.
My lord.
What happened? My lord, you must tell me the fact. The court has quashed the NBW dated 19/6/2023 and asked you to go and appear.
Appear. But my lord, the petitioner did not appear, my lord.
Then one fresh NBW.
No, my lord.
Then
Extension of time, my lord.
there is no time was granted. Where is the time was granted? Just see. 2/12/2/8/2023. Where is the date given?
My lord, 2/8/23, my lord.
What kind of extension you want? There is no date given, sir.
Still, the order, I think that the order is continuing.
My lord.
The order is in force.
You appear, go and appear in next date appearing. No date is given. I don't know what is the next date appearing. Go and appear. Who stopped you? Why are you moving this application?
My lord.
Simply land council petitioner seeks to withdraw this application. Which stands withdrawn. 27.
27, I pray for 1 week after mine.
Yes, adjourn. 28.
Date I prefer adjournment, my lord.
Adjourn.
No. Okay.
29. Password. 30. 30. Password. 31. 32. 33.
My lord.
You are there?
Item number 32.
32. 32. Tell me.
My lord, I am appearing for petitioner. My lord, I am kindly taken up to be in next week.
Urgent.
Okay.
33. 34. 35.
May I please, lordship. On behalf of escape, I pray for password.
Pass.
Obliged.
36. 36. 36. 37. 36. Yes.
Lord, it's a case for a finance officer of a company to be implicated in a case of an accident in the blast furnace of that factory. Lord, I'll just request my lord to see the previous orders. Order dated 7th of December 2023.
Yes, Mr. Maharaj.
My
You are appealing.
yes.
You made the statement that some preliminary inquiry has already been
Yes,
conducted.
yes, my lord.
What is the
My lord, the copy of the instruction has been submitted before your lordship, my lord.
Nothing reported against this petition. I am a finance department officer. How am I connected to the blast furnace, accident in the blast furnace? That labor union lodged FIR implicating everyone. in
Your
the world.
lordship just have a glance to the para 16, my lord.
16 for the report?
Report, my lord.
Yes.
The cause of incident and shortcomings such as details of unsafe condition as unsafe.
Correct.
Act are both for which the incident occurred to be described, my lord.
Kindly see, Lord.
Chrome ore.
Should I place it?
Defines cannot be used directly in the melting of furnace for the use of safety and type of furnace. We define chrome ore, therefore, okay, and use for the
Page 21.
hard line. These are the process used.
Yes.
Process, but
So from
what are the
Role played by the petitioner.
overtake
Yes.
attributed to this petitioner?
My lord, they should have taken the safety measures properly.
Who are they? Who are they? That is important. What is their role? The financial officer. They are not technical.
This person is financial.
So that is what his case is. I am financial officer. I have nothing to do with the overtake imputed against the accused persons. What is the role attributed to this gentleman?
That's right.
Of course, my lord.
Just see the complaint and see the FIR. What is the role attributed to this man? Whatever you are saying is correct.
Yes.
Taking that to be correct also, whether any case is made out against this gentleman, that you have to address. If you are not ready, I can give you one date, but according to me, nothing is attributable to him insofar as this
Password.
Password?
No, my lord.
My learned
Have you, Mr. Rahul, have you gone through it? Just go through it. Don't worry. Go through. I'll pass it over if you want. And
Yes,
if you
sir.
want, I can give you one more date, but be satisfied
Yes,
yourself.
my lord. Yes, my lord.
Be satisfied yourself. No problem. I will pass it over then.
Yes, my lord. Pass it over or Arjuna another day too.
You tell me which date you want.
One day after.
Not date will be delayed. Because this matter you have to examine qua this petitioner, what is the role attributed to him? What is his responsibility in this, even if this is accepted to be correct? I am taking this to be correct.
Yes.
Whether this gentleman is responsible for whatever the technicalities are being spelled out here, he is not responsible. He is a finance guy. That is why. You just check it out.
Yes.
Let him.
Definitely. He should be satisfied. Definitely. Absolutely correct, my lord, except 21st.
But kindly place it on record. You kindly place it. File.
Flag A is there.
Okay, flag A.
It's filed by the state.
Okay, very good.
But I only request, my lord, except 21st. 21st, my lord, I am not there. 28 would be, can it not be 22nd or 20th? Have they have? Then, yes, let it be 28th.
I don't think that is filed. Flag A is not there.
So
Flag.
I can give it.
Flag C. This is flag C.
Okay. So need not.
It's there.
Need not be duplicated, my lord. Why should?
Thank you.
Correct.
37. ଆପଣ ସେଇଟାକୁ ଟିକେ ଖାଲି ଏକ୍ସାମିନ କରିବେ ତାର ରୋଲ କଣ ଅଛି ସେଇ ହିସାବରେ ଠିକ ଯିବ। There already. 38. 37. I just come 38 on
33 ଟା ଡିଫେକ୍ଟ ରେ ଅଛି ମୁଁ ସାର୍ଟିଫାଇଡ୍ କପି ପାଇପାରିନି ଆଡଜର୍ନମେଣ୍ଟ ମାଗୁଥିଲି ପାସ୍ ଓଭର ଆଜ୍ଞା
ଆପଣ କୁଆଡେ ଯାଇଥିଲେ?
ମୁଁ ଲିଫ୍ଟରେ ଆସିଲା ବେଳକୁ ଲିଫ୍ଟ ଅଟକିଗଲା ସେପଟ ଲିଫ୍ଟରେ
38 ବି ଏଠି ନା
33, 38, 37
ଶୀଘ୍ର ପଳେଇ ଆସିନ ପଳେଇ ଯିବେ
ଖାଲି 36 ବି ନେଇଛନ୍ତି ନା କମର୍ସିଆଲ ବ୍ରେକ୍ ହେଇଛି କମର୍ସିଆଲ ବ୍ରେକ୍ ନା
criminal miscase. It will be miscase IA.
Sorry, which order?
Order 27/2024. Last line, para 5. The criminal miscase is disposed of. It will be IA. Instead of that, the IA, because the previous paragraph, Lord says, paragraph 4. It was IA was disposed of, not the criminal. Learned counsel for the petition submit. The matter is fixed either before the court below today. If further submit that, it would be moving appropriate application before the court.
Main matter is pending.
Main is pending. Main is pending.
Right now. The main matter is pending. Right now. And the application of modification. Modification as per the order dated 27/2024. And in fact, criminal CRLMC, the present CRLMC is still pending. The order dated 27/2024 will be passed in the MAR.
IA 3000 by 2023.
3000.
24.
3000.
3000 by 2023.
The para 5 of the said order is modified in the following terms. IA number 3000 of 2023. Item 40.
May I please, so here the petition is challenging the question of criminal proceeding lordship on the ground of compromise. Compromise. Last occasion, lordship will issue notice to the OP, a private OP2, and the notice made sufficient. Noting is there, lordship. Notice is made sufficient.
Why don't you bring her?
से टिके पिटिशनर बाहर अछन तांको इंटिमेशन दे लास्ट टाइम लिस्ट हला परे ठीक है लॉस्ट
You bring the informant and
लॉस्ट टेकन अप नेक्स्ट वीक
why are you waiting for the notice to be heard? When will you bring that?
on 27 2 notice was issued 27 2 was issued
27. It says 27.
नहीं 27 नो से तार गोटे ताप जानो अप्रैल फर्स्ट वीक रे बोलस
Third.
हां रहो एनी डेट ऑफ
You bring
लॉस्ट
41.
One, my lord, I have filed counter today in court. I have sub copy to my friend.
Well, I've received the copy of the counter just now.
You want to respond?
Well, I'll just go through it so that the next day we can.
Mr. Agarwal, for appearing for the enforcement director, has filed the detailed counter affidavit and copy of the same is supplied to Mr. Pandal and also the petitioner, and this is the matter for this. Annexures are not, there is any.
There is no annexure, my lord. I have quoted everything.
Counter affidavit is taken out.
Public.
My lords, am I fixing any date?
A date.
My lords, there was an interim order that the petitioner will.
My lord, interim order is, in fact, virtually that interim, only order was he will file an application and
Oh,
court.
that arrangement is.
That arrangement is also there. There is no, there is.
There is an interim arrangement that is what.
That,
Mr. Pandar requests that he would avail the
file an application and
avail the benefit granted to him
earlier granted to.
earlier granted on 3/1/2024.
Yes.
If advised so.
Oblate.
Item 40 interim order is there. 40 interim order is a settlement matter. 42.
My lord, item 42, two matters are there, your lordship. In CRLMC number 618/2023, that has been filed for quashing of the criminal proceeding on the ground of compromise. In that CRLMC, your lordship, joint affidavit is there, your lordship.
Where are the parties?
Party cannot come because he is 9-1 pregnant, your lordship.
Huh?
She is pregnant, informant, victim is pregnant, your lordship. Kindly see the affidavit, tentative date.
No, opposite party number 2 is.
My lord.
What about petitioner?
Petitioner has not come, your lordship.
Petitioner is accused.
My lord, he will come, your lordship.
Till 2 o'clock.
No, my lord, he may not Balangir.
Tomorrow?
No, no, my lord. 2-3 days.
Online, let them appear.
Yes,
on.
Yes, lordship.
Tomorrow?
Tomorrow online, your lordship.
Tomorrow 2 o'clock.
At Balangir court, he will appear.
Yes.
My lord.
Let him appear. Matrimonial dispute.
Yes, yeah.
They have settled.
Yes, lordship. Settled, they are living together, your lordship. Now she is
Not matrimonial dispute. 376 POXO.
376 POSCO is there.
And the present application is recalling 311 person have been challenged.
Oh.
It's not a case of compromise. I
My lord,
disputed that.
my lord, two cases are there. Or before your lordship, two cases are there. CRLMC 618 that has been filed prior to the CRLMC number 4959 of 2020.
The victim has already deposed before the court.
Exactly.
Thereafter, you moved application 311 to. You settled the dispute.
My lord.
The girl is now pregnant.
My lord.
Now you want that the girl should come and depose in your favor.
No, my lord. Both are married.
But POXO is there. In the absence, how can we? She is pregnant or
My lord,
not, who knows?
both of them will appear. If your lordship give time, both of them will appear, your lordship. Or your lordship allow the 311, then also purpose will be served, your lordship. Then your lordship directed to appear, your lordship. Fixed a date in the month of April, your lordship.
Second, very difficult situation. Life of this girl and.
My lord, there is love affair
Life
between
is in the midst of the society.
love affair was
He
there.
is on bail. No.
Yes, lordship, on bail. After religion bail, both the family perform their marriage.
They are staying together.
They are staying together.
Take the evidence given the
Evidence is.
after the evidence they perhaps staying together. After the evidence.
No, no.
Before evidence came the staying together and deposit.
For evidence, why
Bail the page. Compromise.
वो कथा
My lord,
after her
in evidence also, the victim has not stated about, only said about the relationship, but not alleged against the petitioner, your lordship.
Some kind of recall coaching happen.
out their problem.
So you will be acquitted.
Not acquitted case of physical relationship party is there, and this is a case of POSCO, but consent is
You
there.
might have said that.
And say evidence copy to. So party
Then I'll give a direction to the trial court to immediately conclude the trial. If there is nothing, no material is there.
Evidence.
My lord, Bojuna, material in the sense this is a case of 376 POSCO,
Yes.
and evidence of physical relationship party.
Then why should it come?
Well, tomorrow they will appear on VC.
Give some time.
Well,
Very-
हाँ दी जन appear करी परिबे
टाइम नहीं तो
कहने 10 अप्रैल को डेट अछि your lordship
Stay तो कर देती कौन प्रॉब्लम है?
स्टे तो
Stay तो अच्छा।
there is no problem.
The trial court proceedings.
ना 10 अप्रैल को
Because
Delhi
I'll tell you why I'm giving you date.
my lord
Because the time has its own value, you know. Or time may heal. Out of pressure, he might have said, okay, I'm married. Thereafter, he will start torturing this.
my lord 10 April date is there for tentative date for delivery is there 10 April.
After delivering them.
My lord.
Little more time. 24.
My lord.
why we are all suspecting because incident happened in the
Right.
inside the
She has deposed.
My lord directed to appear
164. See, you may be correct. It's not, you don't treat it as a case. Treat it as looking into the welfare of the
my lord
girl child. See, 164 she has stated. She went to the court and she has also stated. And thereafter you settle. Why you settle? Because
your lordship kindly try to my lord kindly try to understand me. She has given evidence in court in favor of me except the physical relationship. As case of case of
in favor of you.
my lord like my lord ଆମେ ଦି ଜଣ को ଭଲ ପାଉଥିଲୁ ଭଲ ପାଇକି ଆମ ଭିତରେ ଶାରୀରିକ ସମ୍ପର୍କ ଥିଲା ସବୁ ଜିନିଷ case of consent but case of
this case, say check bounce case, 205 petition has been rejected by the. I am the accused. 205 petition was rejected by the London court below.
205. Where are you?
I am from Andhapur.
Keonjhar.
Yes, my lord. The fitter Delhi.
Keonjhar, she is also, he is also Keonjhar. What
हाँ,
is the problem?
Delhi worker.
Huh?
Delhi worker.
What is the check amount?
50,000.
Why don't you give?
ସେଟା ସେ ତାର ମୂଳରୁ ଆକାଉଣ୍ଟ ନାହିଁ ସେଟାରେ ସେ ଦେଇଦେଇ ଚେକ୍ ମେନ୍ ପ୍ରୋବ୍ଲେମ ସେଠି
Where you got the check?
ଆକ୍ସିସ୍ ନାଇଁ ଆକ୍ୟୁଜ ଦେଇ ଯୋଉ କମ୍ପ୍ଲେନାଣ୍ଟ ଦେଇଛି ଆକ୍ସିସ୍ ବ୍ୟାଙ୍କର ପୁଣି 2004 ର
चलो इशू नोटिस असला पर किसी पैसा नहीं ऐसा करेगा पर खत्म करेगा इशू नोटिस टू ऑपोजिट पार्टी नंबर 2 meanwhile the petitioner may participate before the court below in the proceeding through his lawyer. Yes. You participate in your lawyer.
Yes.
Right.
Obliged, ma'am.
44th.
My lord, quashing of the criminal proceeding under the ground that the both parties have divorced to each other, my lord. Order of the divorce is annexed to my lord. And the petitioner had already paid 4 lakhs rupees towards maintenance and
Why don't you bring her?
my lord,
You bring her.
my lord.
You can.
My lord, she is now staying with his father's house. My lord, notice may be issue.
Okay, you issue notice.
Ma'am.
Issue notice to the opposite party. Mr. Maharaj, I appear for the state in week's notice. And then counsel the petition submits that the parties have settled their disputes and persons thereto. They have applied for dissolution of marriage by mutual consent.
Mutual consent.
By mutual consent. The family court, Jagat Singhpur,
Ma'am.
wide order dated 4/4/2023 in civil proceeding 94 of 2022 has already allowed their prayer and dissolve the marriage by mutual consent. Mutual consent. In the meanwhile, the proceeding for court.
My lord. Stay of the further question. Okay.
45.
May I please, your lordship, my lord?
Yes.
The petitioner challenging the order of taking cognizance, my lord, by the annexure 3. Charge sheet submitted against us under section 294, 506 and 34, my lord. But cognizance has been taken under section 294, 323, 354B, 506, 450, 376(1), 342, 34 IPC. मतलब charge sheet portion is my lord.
What is your case?
Case against us is one Kamala.
Case is you have not got anticipated bail.
No.
You got.
Oh, we have the only charge sheet submitted 294,506, my lord.
Then what exactly you want?
The cognizance against of offense taken, my lord, page 39, annex 3.
40, page 40, yes.
39 is the
294, 323, 354B, 506, 34, 450 and 376.
But fact is that charge sheet submitted against under section 294, 506, 34, page 38.
Material must be there.
Segregate cognizance never 34 is there. So
material is
might be
what is the problem?
and question is you have to raise.
Why you raise all the things in the charge stage? Why are you unnecessary?
Injury टा इतने छोटा टा अच्छे सेटा treatment को
ताको अपन charge रे आर्गू करो
ना injury totally non application of mind my lord because I'm reading one page 38 is prima facie evidence under section 450 376 1 294 342 323 354B 506 34 IC is well made out against the accused number 1 Kamalakanta Jana. He is not the petitioner here. And under section 294 506 34 IPC is well made against the present petitioners.
This is the police inspector who is saying. Who has a superior brain? Police inspector or the magistrate?
But
magistrate is applied. See, these are the opinion of police inspector.
What is the material? I am submitting.
Material, show me the material.
Yes, I am submitting. The
material, you have not filed anything.
Yes, I am submitting. The page 48 statement of the informant.
But all these things, sir, you can argue all these
things. All these things, my lord, usually when the cognizance taken always against the offense, not against the offender, my lord.
I am saying
offense. But usually
you argue those things in
all the offenses, my lord, simultaneously that has been taken, my lord. Cognizance against offenses.
Those things is before the
exactly
framing of the stage of framing of charge. I'll give you that liberty.
My respected submission, my lord. Injury जेतले छोटटा अछि ट्रीटमेंट कर देले भलो जेतले कैंसर हबो कोनकोटा कटा जो देख
ऑलवेज यूजुअली सेम my lord
कैंसर जो कैंसर ପାଇଁ जो डॉक्टर माने सेमान कोन करी
सेतले पूरा से बॉडी रो पार्ट नै कटा हे जो तणो इनिशियल स्टेज में the cognizance
giving all liberty to you.
My submission matter. The word is the cognizance means application of judicial mind and the prima facie material. There is nothing in this case matter. No prima facie material and application of judicial mind matter. The statement of the informant doesn't say anything against us matter. Only allegation one Kamalakanta Jana and he is dead now.
All these things, you know, I need to go into at this stage. You tell me unnecessary charge stage. Therefore, there are stages. You can elaborately argue also.
Charge frame. So you are responsible for this, and you have to answer this.
In my grounds, I have taken the several judgments of Hon'Ble Appellate Court as well as the one.
Joining issue with you that the court doesn't have the power, but you can get better. That's what I'm saying. Suppose I
नहीं सर मैं
make
बताती
up mind
हूँ
saying
आप
that no
जूम मीटिंग को जब आप करोगे ना ज्वाइन मीटिंग तो आपसे सिर्फ पासपोर्ट पूछेगा ठीक है आप उसको एग्जिट करें
you know avenue. That is why.
हाँ जी जब आप एग्जिट करिएगा
then I'll read it. I may say that yes, prima facie case is made out. Then your
जब
charge is
एग्जिट
gone.
करिएगा
Where is the ground? Where is the material? That prima facie case is made.
I'll have to go into the.
No, madam, I am submitting.
नहीं आप सीधे जूम खोलिए
Because only the informant is whose statement recorded. She has nothing told anything about us, my lord. All the allegation against one Kamalakanta Jana.
What are the other evidence? The charge sheet is only this much?
Yes.
Or the other materials are also there?
Or the 161 statement there, my lord.
Where are the? Then you file everything.
I filed. Annexure 4 is the 160 statements.
You want me to go into a right point? Right. At this stage, risk is yours. I'm ready to do it. That's my job. I have to do it. I'll do it. But
and I will get nothing, madam. One of the such case.
I tell him, you go and argue, I am giving all liberty and you will come back. You will come back. That liberty I am giving.
Yes, one just submission.
Yes.
One in Sunil Bharti Mittal versus CBI, Honorable Supreme Court is held like this manner. For that, the mere statement that he has gone through the complaint, documents, heard the complainant, as such as reflected in the order, will not be sufficient. The order is liable to set aside if no reason is given then, while coming to the conclusion there is prima facie case against the accused.
He has given state. He has written it.
Only written prima facie case, but
That is enough. Very incognizant. You know that. Who knows better than you? I'll just give you that liberty. The letter counsel for the petitioner seeks to withdraw this petition, reserving his right to raise all these points before the trial court at the stage of framing of charges. He further raise for grant of liberty to move appropriate application before the court below under section 227.
Yes.
227 CRP. 227 CRP. With the aforesaid liberty, the petition is disposed of. You move application and narrate everything so that you may be discharged also.
Maybe 376 are charged.
I have seen
It's separate.
it would observation then you may be out. After 227, again you can come. 46.
On behalf of Mr. P.K. Kar pass out.
Pass out. 48.
Lordship, kindly be taken over after next 2 weeks. Internal order content.
49.
Okay, Lordship.
With great respect, your lordship will permit me to appear through virtual mode, my lord. This is a matter which was which had come up in on 6th of February, my lord, and this matter was disposed of, and detailed order was passed, my lord. I just want to make it clear, my lord. Just before I come to that order, I have reproduced a chart at page 4 of this application because a lot of prejudice has come towards me that I have filed multiple litigations. So your lordship may have para 4 at page 4.
Which is your application 608?
My lord?
Now
this 608, my lord. IS 608.
I got the chart.
Yes, my lord. So I at all stages, my lord, my petitions somehow became victim of this multiple litigation. So it is necessary that I place it before your lordship.
You tell me one thing. How many lawyers do you have?
Your lordship, yes, there are different lawyers who have represented, my lord. There is no, in this matter, I appeared, my lord. That's why I am appearing. Otherwise,
you are saying, I take it to be correct. Then the other lawyer comes and says that something else. So your client is not honest to his own lawyers. That's the whole difficulty.
My lord, maybe. My lord, just may have this, with great respect, my lord, may have this chart at page 4, para 4, my lord.
Yes, I am on that chart itself.
First matter was, my lord, to seek bail, anticipatory bail. Your lordship rejected. I disclosed in this petition. There is no suppression of this. Second matter is, my lord, challenge to cognizance having been taken. So this was independent remedy, my lord, and this is still pending. And third matter was, my lord, to challenge the order not granting me exemption under 205. So this was the third. And fourth was, my lord, the quashing of FIR. So these are 4 different causes of action on which on different dates petitions were filed, my lord. There is no doubt that in this petition 172, which is at D, all the details were not there. Only few petitions were disclosed. This is a matter of propriety. They should have been mentioned. But the way it came against me, as if only on one issue I agitated many times before this honorable court. So this is one issue, Your Lordship, I wanted to first clear. Now coming to the order passed by Your Lordship on 6-2, that Your Lordship may have at page 16, though the order starts at page 12.
Right.
Para 9, my lord. Having heard learned counsel for the parties, I am of the considered view at this stage the court need not go into the disputed facts, etc. And then Your Lordship will come at page 17. Para 10, last 4 line. He is suffering from oral cancer and recently he has undergone medical procedure as well. Therefore, he submits that lenient view should be taken, etc. And then para 11, Your Lordship, I have second line. I leave it open to the learned trial court to take appropriate view in the light of the fact that the petitioner is suffering from various ailments. However, he needs to surrender. I went to the learned trial court, my lord, and thereafter, this application is at page 32, my lord.
What happened then, sir?
Your Lordship, I just want to show these 2 paragraphs. I'll not read, my lord. Para 12, my lord, and then para 14, page 35 and page 36. I explained everything. Para 12, I have reproduced the order. Para 14, my lord, that this is the problem that I am suffering, my lord. And then para 15, thereafter the order passed by learned trial court is at page 44, my lord.
Yes.
Page 44 on 29/2/2024. Last 6 line, my lords. If Your Lordship has learned, defense counsel further submitted that the accused person is undergoing treatment since the year 2016, which he has to run after different hospitals for his survival, etc. Hence, he would be unable to attend the court on each date of posting. To suffice his contention, defense counsel has filed various medical documents, which is also part of this honorable court's record, my lord. And thereafter, page 46, my lord, the para in the middle, third para, peruse the record. Now, after perusing the medical document in the middle, my lord, 4th line, medical documents file reveals that the accused person, namely Anshuman so-and-so, is suffering from this problem since 2016. So this problem is admitted. Nobody has doubted. On perusal of the record, it is found, my lord, why it is rejected only because that one of the section attracts life imprisonment. So that is the only reason that I am not granted relief, my lord. And page 47, I am said that, see, since you have not surrendered, you must not get any relief. At this stage, my lord, the issue is that charge sheet is already filed. It's not at investigation stage. There is order of this honorable court for the trial court, learned trial court.
Then precisely you are agreed by this order,
my lord, and I have come with only. I am not challenging by substantive petition. It's in pending disposed of matter, my lord. The direction, the indulgence that I am seeking from Your Lordship is that the direction was to surrender on 29th of February. Thereafter, I have again been detected a fresh tumor, my lord, that I have placed here, and for that I have undergone surgery. I have just come out of the hospital.
What do you want, Mr.
I am saying, Your Lordship, if there are 2 issues, my lord, in the prayer itself I have placed that this order of surrendering, my lord, may be extended for 2 months, and Your Lordship also kindly considering, because 205, the very purpose, my lord, is that these kind of situations where there is no objection to the fact that he is suffering from cancer and he is in serious position, that he should be permitted to appeal to VC.
What will happen? Even if I extend for 2 months, then you have to undertake the same, procedural remedy available to you.
My lord, every case has different facts, my lord. This case is serious. This case is of different kind of seriousness. I bow down, my lord. I would not have come again and again before this honorable court.
I have all the sympathy for you, but the conduct is so apparent on record. So see, twice the cost has been imposed on you. Still, your client is engaging different lawyer and not coming clean to the court. That's the reason,
My lord, that is the precise reason, because in the
having all kind of sympathy for you because you are terminally ill. Sometime you are forcing the court to take a view that the sympathies are misplaced.
There is some mishandling of this. There is no doubt, and I am appearing only because of the reason that in this matter, first time I appeared. That's why I was requested. Otherwise, I would not. Otherwise, again, I will be accused that I have been.
I can use that expression. Concession given to you on that day has been availed by you, and the court has passed an order. Now you have a specific remedy to challenge that order. You can do it.
My lord,
only what I can do is I can extend the time.
My lord, and one more thing, my lord. He can be permitted to appear through VC, my lord. The charge sheet is filed. When there is his presence is required for recording something 313 etc., he will go, my lord. But he may be permitted to appear through VC, my lord. That's the limited. Otherwise, how? Otherwise, my lord, there's difficulty, my lord. My lord may consider sympathetically. Mr. Maharaj is here. I can't do it because I can't go beyond, my lord. Last time also.
I'll tell you, Mr. Samshad, everybody has sympathy for you.
Yes. Yes.
But what to do? She conduct is so bad. So bad. Yeah, 367 you कत्ल की मुकदमा बना दिया.
And bank has been paid partially. Bank has been paid partially. They are redeeming that the bank is not a complainant. Bank has no objection till now. This, my lord, something must be done, my lord. He may be permitted to appear through this.
He's getting desperate, moving here and there because of his illness.
There is also only had it been in hand.
That's the whole difficulty. That's the whole difficulty.
We are all in favor
See, the
of
other day, Mr. Maharaj conceded, but what to do? You have created this problem. Yes, sir.
My lord, I can't say.
If tax is subject to correction, if tax is it's a right to change lawyers to lawyers, change application to application.
No problem.
And without expressing or mentioning or intimating the lawyers, those are conducting the
He
case.
may not be knowing all these things.
That is all these things.
Mr. Pradhan moved an application, thereafter modification application. So
I got to know. I have placed all this with this record. I have placed everything. These are part of this. Now I have been told everything. I have placed everything on record this time.
Disposable.
My lord, both the prayers.
Allow him to appear through this.
Because only on the ground of that suffering from cancer.
Yes,
that
exception.
That needs a consideration. I don't dispute that.
Right. See, by the order dated 6/2/2024, this court has partially allowed the petition moved by the present petition. The order needs a pursuant to the aforementioned order, the petitioner moved an application before the court below under section 205 CRPC. In the said application, he had placed on record various documents to substantiate his arguments, substantiate his case that he is the terminal ill. Therefore, he is not in a position to appear before the court. The learned court below, by the order dated 29/2/2024, endorsed the fact that the petitioner is terminally ill and suffering from cancer, and has also taken note of the fact that he has been undergoing treatment since 2006, and subsequently his health is also reduced.
However, the application under 205 CRPC has been rejected on the ground that one of the offense attracts one of the alleged offense alleged to have been committed by the petitioner under section 467 IPC attracts liability. Therefore, the application under 205 CRPC deserves no merit. Accordingly, the application was turned down. The petitioner has for modification. Earlier present petitioner has also repeated similar prayer before this court by filing various petitions. The court has taken a serious view regarding the concealment made by the petitioner.
Earlier, madam. In this, I have not.
By moving repeated applications without disclosing the pendency of similar application before the court. To explain that, the petitioner has given a chart in para 4 of the present application. Mr. Sunshad, appearing for the petitioner, made an attempt to explain that the mistake has committed is a bona fide mistake, and all the petitions filed by his client are for different relief, though the pleadings are same. So therefore, there was a confusion. Earlier, this court had imposed cost on the petitioner for having concealed the material fact from the court. However, the fact remains that the petitioner is indeed suffering from terminal disease since 2016 and has been under treatment, constant treatment, and his health condition is further deteriorated. Mr. Maharaja, appearing for the state, submits that the petitioner has been petitioner out of over anxiety has been repeatedly approaching the court by moving different petition for similar relief.
Engaging different counsels.
But
engaging different counsels.
And engaging different counsels. But at the same time, Mr. Maharaja submits that the fact that the petitioner is suffering from terminal disease like cancer is eminent from the record. Therefore, he submits that even if the application under 205 CRPC moved by the petitioner is allowed, he must appear in the court through virtual mode, so that the trial should not be hampered. Next problem. Taking into consideration the sequence of events unfolded in the present case and the fact that the petitioner is indeed suffering terminally, suffering from cancer. I am of the considered view that the petitioner should appear before the court through virtual mode on each date of hearing, without pay, so that the trial could proceed. The petitioner is also the counsel of the petitioner undertakes before this court that he would not seek adjournment on any pretext before the court below, so that the trial could proceed at a pace expected to proceed in the present. With the said observation, the application is allowed.
One line, my lord. That whatever legal remedy
that may be allowed, my lord.
Mr. Maharaja further submits that he should
I'll paste 205 application.
Press application.
Understood.
Press application at 2055 CRPC inter alia making the prayer that he should be allowed to appear before the court through Vishimo.
Which the learned trial court will allow, my lord, because all the time we have been asked.
I have given that, don't worry. And if such application is moved, the said application shall be considered by the court below, favorably, and thereafter the of your honor. But advise your client.
Your lordship may do that. Your lordship may do that it here, my lord, because all the time I know that I have been asked to first present and then press this application.
This much indulgence is given because of Mr. Maharaja's leniency.
I am so deeply obliged to the court as well as the consideration extended by Mr. Maharaj.
To balance things, so therefore he has done it. Be happy with this.
My lord, one line, my lord, one line, that he shall be free to take whatever legal remedy, my lord, because many litigation has come and now I have explained everything, placed every order on record till date.
Every small observations are being misused by filing repeated petition before court by your client. So no observation.
Your lordship.
You have got more than enough.
I am so deeply
more than expected.
I am so deeply obliged, my lord. The condition is such, my lord, otherwise I would not have made
so that is the
so
reason
much
the
of
indulgence of the court.
Your lordship, please.
That's the
Your
only
lordship.
reason. That the person
I am
who
so
is
deeply obliged.
so terminally ill, but still,
My lord. He deserves this, my lord, because at least this much, my lord. I am so deeply obliged.
Otherwise, Mr. Maharaja is very tough prosecutor. You would not have considered.
I respect him for this, my lord, because every prosecution has to be handled with toughness. But there are certain occasions where the toughness requires little flexibility, my lord.
Right. Okay. Thank you. Yes. Item 50.
I may please, my lord. My lord, in this case, the earlier order, I was directed to appear before the court, my lord, and my NBW, which has been issued against me, has been recalled, my lord, set aside. But, my lord, my only submission before the honorable court that on my appearance, the learned court should allow my petition taking into consideration the principle settled by the honorable apex court in the light of
What was the offense?
offense is 380, my lord.
380. Why are you worried?
The problem is, my lord, allegation against me that I was involved in a case of theft in which the court's record has been taken away.
Oh.
It is alleged that on my instigation, things has been done.
You are court staff.
No, I am an advocate. And it is alleged that the person who has taken away the file has taken away the file on my instigation. So there is every chance that the moment I will appear before the learned court.
But even then, the offense is 380 only.
Yes, my lord. That's why I'm telling. That taking into consideration the principle settled by the apex court in the subtendere until my case.
It's not applicable to this case. Absolutely not applicable. How it is applicable, my learned senior may satisfy this court. And I am here to.
You are a lawyer. You have indulged in theft.
No, my lord. That is not the case. The case is one person along with his clerk came to the office, took away the file. And subsequently, when that person was taken into account by the staffs, he confessed that on my instigation he has done.
What do you want? You want modification?
I want that the moment I will
whatever judgments are there, you show to the court to stop you.
My lord, if it will be mentioned in that order, it will be better.
What judgment you will show? Why should the court will make you show whatever you want to show? So what is who stops you?
No, my lord. If it will be mentioned like accordingly, I will be obliged.
I have only said that you appear and
yes, I'm telling that on my appearance, the principle settled by the apex court may be taken into consideration by the court.
I can only add one thing, that he will appear and avail remedy on the basis of the judgment settled by the court.
Yes, my lord.
Whatever judgments are there, judgments are there, we can't say anything.
That will be considered in accordance with law.
No, obviously, I can't allow the.
Yes, sir.
Sir.
And you have not surrendered so far. The
No.
time has already gone.
No, Miller. Date has been fixed on 20th, Miller,
20th
of this month. Miller.
what's the time? Na?
Yes. And I'll pray that some more time may be allowed because by getting this order,
I will extend the time and
Yes,
so that modification by the order dated 23/2/2024, the NBW issued against the petitioner by the order dated 25/8/2023 has been set aside. And the petitioner was granted liberty to appear before the court below on or before 20th
March
2024 and seek remedy available to him under law. By way of the present application, he seeks extension of the time for further period of 15 days.
Yes.
Further period of 15 days. The 15 days. 15 days. Accordingly, the
Miller,
application,
yes, ma'am.
order dated 23/2/2024 is modified, and the petitioner is granted liberty to appear on or before 15th of April 2024 and seek remedy available to him under law on the basis of the settled principle of law enunciated in
Satyendra Kumar Until
Satyendra
versus CBI.
Satyendra, until you rely, you get given.
Yes.
Okay. I have extended till 15th April.
Yes, ma'am.
And noted down that also.
Yes, sir.
The code will apply.
Yes.
Yes. 51.
All right.
When my lord, what application, my lord, I file application. The para 5 I mentioned, my lord. The PS case number wrongly mentioned as 298 instead of 297. 51, my lord. I mentioned para 5 of application, my lord. Page 3.
Para 5.
Page 3.
Only, sir. Yes.
Para
PS 5.
My lord.
PS case number
297, no? 298 is.
90 केतला
97 297 हवा
हवा कथा
हां 298 है
297
हां
298 what पड़े
in wrong in paragraph number 2 and 5 correction made in paragraph 2 and 5 with order, my lord.
ठीक है 297 right now the petitioner is seeking modification of the order to the extent that the PS case mentioned in para 2 and 5 in order dated 27/2/2024 is mistakenly written as 290 PS Jamakhandi PS case number 298 of 2023 instead of 297 of 2020. The modification application is allowed.
Another my lord, offenses, my lord. Add over 376 and 511.
Offenses are also.
Also. 241, 294, 323, 534. Add up 376 and 511.
Yes, that is there in the annexure 1.
No, my lord.
Annexure 1, therefore. And there is a typographical, there is a typo insofar as the offenses are also considered. The state typographical error in para 2 and 5 is corrected. To be read as the Tomokondi PS case number 297 of 2023 corresponding to GR case number 1149 of 2023 under section 8 नहीं जो annexure 1 annexure 1 FIR नहीं तो बोलेगा ठीक
I have also mentioned in para 5 man
52
please lordship pray for adjournment.
Why? Argue, what reason? You tell me.
So his senior is out of station, so
Who is your senior?
Sibo Sankar Mishra.
What is this matter? You can't argue.
No, sir, not file is not with me.
Urgent.
53.
May I please? Modification, my lord.
Yeah,
My
what
lord,
is-
inadvertently, my lord.
Every day,
My lord, not due to my fault, my lord. Sorry, my lord. And inadvertently, instead of additional distance session judge, Hon'Ble wrongly typed as distance session judge in the cost title, my lord.
You have written what to do.
My lord, sorry, my lord. Sorry, my lord. Resulting in the same defect in order sheet number.
What is this? Change karo, additional signature karo.
My lord. So order number 2 re
29 to 2024 रे.
yes. So खाली ता proof additional जुड़ी हो.
तार खाली additional जुड़ी. ये district and session judge काम special judge करना मर जाकर रे. Additional district judge.
My lord, my lord.
हला.
Para 2 रे अच्छी, para 5 रे अच्छी.
Para 2 and 5.
My lord.
आपण carefully देखो तो.
Sorry, my lord. यो order sheet ऐसा थला तो बाड़ी दिले.
Anyway.
नहीं, सीधे खाली. Perimeter to correct the cost title, my lord.
हला. Sorry, counter sign करो. ठीक है. Additional जोड़ी दो. ठीक है. 54 है.
54 my This is a change of nomenclature, my lord. But instead of criminal revision, I filed it criminal case, CRLMC, my lord. And this, sir.
Against charge.
Against the rejection of petition under section 239 by learned trial court. That
Yes.
I filed a discharge petition under 239 of CRP, but the same was rejected by learned. So instead of criminal revision, I filed CRLM. So it should nomenclature.
Seek to withdraw petition to avail our medical under the court. With liberty. Next.
Certificate copy, the rejection certificate copy I filed.
Certificate copy of the.
That is under page number 43.
Certificate copy of the imbue order may be returned to the petitioner by replacing a photocopy. ठीक है? Certificate copy.
55.
Apply.
My lord, I am for the OP2. Kindly taken up after 1 week after for further instruction. The status of the trial.
On behalf of Madam Janna, kindly taken up after launch, madam.
But he is asking for time.
He is asking for time, madam.
Further instruction for the trial court, status of the trial.
Now, what do you want? You want an adjournment?
Adjournment for 1 week after.
He asked for an adjournment.
Permit.
Oh, adjournment. Yes. 56.
Let's say in this matter, mediation proceeding are going on.
Sorry.
In this matter, let's say mediation proceeding are going on. Next date is 28th.
Mediation.
Mediation.
Friday.
Kindly taken up this.
Still on. And the
Interim order may be extended.
mediation is still on and
28/3/2024.
28/3/2023. These the matter. April will be the second week.
So interim order may be extended.
Interim order to continue.
Much updated.
57.
I'm appearing for the opposite party.
Pass over करिए आप.
Any date, my lord, next week, my lord, pass over more difficult.
Next week to chance.
Second half, I have some personal difficulty.
Who is
Tomorrow, my lord.
no question tomorrow.
No, next week, also, pass over.
Pass over नहीं था.
More second half, personal difficulty.
For the Mr. Start appearing for the opposite party.
No, interim order के कितना है? ये application ना.
58.
58, your lordship, I am appearing for opposite party number 2, your lordship.
Party number 2.
Notice was issued. He appeared today.
Yes.
Today I am appearing, your lordship may fix it by next week any day. for hearing.
Reply.
Yes, sir.
Reply.
One.
Mukalakama dekho. Correct. Opposite party note 2, 6 time to file reply. Least after 2 weeks.
One line.
My
may be added.
my lord,
Yes.
One line may be added. Many various application has been filed, but no certificate has been given. Your lordship may kindly one line added.
at the instance of the present petition, no application, this is the single application which has been filed. Other accused persons have filed different cases, different applications that are pending. Your lordship has fixed many of the matters to a date.
At the outset, Mr. Maharaja pointed out that various applications are pending before this court.
Under section 482 of
Under
CRP.
section 4.
Filed by other accused persons.
CRP. Which has not been disclosed by the present petitioner.
Yes.
And the counsel of the petitioner submits that the present petitioner has not filed any petition, whereas the co-accused persons have filed many petitions which are pending before the court.
Yes.
Let the detail of all the petitions be placed on record in the next.
Your lordship has fixed a date, some items out of this. I pray the interim order can stay.
No, my lords, no interim. The petition is not maintainable, your lordship.
Your lordship last occasion
The
had me and your lordship directed for issue. It was the
Proceed with the
present petitioner entered into an agreement for sale with the recorded owner.
1 minute. Let us
My
see.
lord.
If he is entitled to it, then we will see. Otherwise, no. Yes.
So in all matters, your lordship not granted interim protection. So for 3 petition, another application is also today. The 482, 4169, 4155, 4087.
No.
No, my lords.
Other accused persons.
So for other in
This case is arising out of the complaint.
similar nature, 3 applications is filed, your lordship. And in all, no, today another matter is 35, your lordship, pass over age.
35 with 35 with
Again.
35 coefficient. और जितनी coefficient होती है बुढ़ा को गोटे tag कर दो.
हाँ,
that confusion.
at a time hearing it.
Confusion. 35 जेतोड़ take up हो, you just remove.
Yes,
Right? So that
yes.
all the matter we will tag and decide.
Right.
35.
My friend is there.
35.
He's there.
Yes.
So your lordship may kindly note it.
Huh?
Kindly note it the numbers.
No down 35.
One date, ma'am, your lordship may fix. I will file a reply to all the applications. Then your lordship will take up the matter. For
In
final.
35, what do you want to say? Yes.
Here also he is seeking for quashing. But difference is that your lordship between 2 matters. Item 35
What are
and
the allegations? Just let me understand what.
the allegations are by making fraudulent transaction, your lordship. I have purchased the land since 2000, your lordship. In 2005, my purchaser, my vendor has transferred the land to accused persons, your lordship. And without suppressing the previous transaction, your lordship, they have transferred from one person to another person, your lordship, by making adopting fraudulent, your lordship. That is the case, your lordship.
Then all are documented. Specific performance, why don't you file specific?
Unless
File
civil-
the declaratory suit.
A civil suit is also pending, filed by the
Yes,
opposite
civil suit
party.
there.
And a status quo order is there.
On the basis of the first document,
My lords.
the first document may be the power of attorney.
No, my lord.
Then
The person
They-
concerned, the person
They-
concerned,
they
sell
say-
deed. Yes, register sell deed made in favor of me. Thereafter, the same person make and register sell deed in.
Registered sale deed.
Yes, sir, lord.
You have a sale deed in your favor
My lords.
and they are the original owners.
No, my lords.
No, man.
They are the subsequent purchasers. sir.
My clients are the
Or the
Who is the
original.
original owner?
He is also accused, but he is not.
They are also-
The original owner has made 2 sale deed. One is in your favor and another is in their favor.
Yes, sir, lord.
They pass on to different people.
Yes,
That's what
yes.
they are-
That
no, my lord.
yes.
Original recorded
That
owner.
is the case.
Justice of case is that one FIR was lost under section 420 of IPC.
So for this case.
And it was investigated. After completion of investigation, final false
FIR was made.
submitted. It's a false case. It's a civil in nature. It has been. Thereafter protesting that, the complainant filed a protest petition. In that protest petition, cognizance taken on section 420, 468, 471, 471.
120.
No. We have present petition that is CRLMC 4169 is concerned. They have filed an application under section 205 and that has been rejected.
205. Are you on bail or
No.
So that is under challenge before your lordship.
So what is this? Is pure
Civil.
I will show you, lordship. I will file my reply, lordship.
You file it, the reply, but they are asking for the interim protection. They are entitled to see you have to file a suit for seeking declaration of that child need to be nabbed.
Yes,
that is pending.
Prima facie, police and investigated file a closure.
Yes,
and on the basis of the protest petition,
yes,
the cognizance has been taken.
Yes,
there are two limbs now. One is police investigated, found nothing. Second is apparently it is a civil case because it is arising out of documents.
Yes,
some child deed is made in your favor from all these things. In the fact scenario of this case, is it not a case for interim protection? Yes. No doubt. Further proceedings in both 35 and 58, na?
58.
Further proceedings also. ICC case number
160.
फाइल करिया पूर्व जदि हम टिके माइंड अप्लाई करन कि रेफरेंस दिया जबो जेहेतु सुप्रीम कोर्ट ओडा स्टैंडिंग ऑर्डर
I don't know why these people are
काहे एमिति करछन कि
why are you doing it?
and we are applying for mind and finding
कोई चीज फाइल कर
Pardon, madam?
कोई चीज
एगुडा सब फाइल हेतला
Yes, madam.
आपण जानि जति
एगुडा थिला ना एगुडा अछि
In our petition.
हां
That when I filed this application, no, I have no prejudice in furnishing the numbers. But on last occasion, lordship, I have given all the numbers which has been.
What it says is,
Yes, madam.
there is a procedure, rule has been amended. Supreme Court says that you have to give it.
Yes.
Why are you justifying not giving it? Simply say, sorry, my lord, I didn't give. I'll give it. Everybody is trying to justify. This happened, that happened.
Yes.
Why? You have to give it, you have to give it.
If not given, then whenever it came to your knowledge, you should just file a memo.
File a memo means.
These are the cases are pending.
Right.
Yes, today. Just now I am filing. Ma'am. All other cases which are pending.
35 voter stay call the voter stay
Voter stay से common order.
voter 35 रे खाली नोटिस कर दियो आ आगे करो मैटर 58 ना आपन
58.
58 रे स्टे कोटे कॉमन ऑर्डर कर दो बोलते
35 जाटा 38 58
कॉमन ऑर्डर कर दे 35 दिया और दिले कॉमन ऑर्डर 35 दिया तो दिले नंबर लिख कर take he also
say sabuta case oda list
Furnishing the memo. Just now.
you are the memo.
Yes.
जो memo टा देबे सेटा
All the pending cases.
take the आपको काउंट
Yes.
फाइल कर दो
yes, sir.
why don't you send it आपन केते दिन
सेटलमेंट हे पारन
लैंड ये किन सारलेनी सी आपको तक भी किलनी चारटा हैंड पळेला
से कोडे कोडे बोले
लैंड यू आर नहीं
land of the land is in our possession.
There may be many claimant now. Don't worry.
Set
You won't get your land. Better that you take the money.
से सब
You will be safe. Otherwise, you keep on litigating. You are right. You will not get the land.
पूरा से मिक्सचर
Mixer है कि वहाँ कितनी बड़ी बात? वो जाने खत्म कहीं करना.
Civil suit is also pending. Status code.
कितने पूछे थी आप कौन?
instruction nabi.
Even if you find specific performance, you remember section 20?
Unless
Section 20, you remember? Specific performance may not be given to you, but some interest will be given to you. How much you have paid, you tell me. I'll ask them to pay with interest and finish that.
I will take instruction.
କେତେ ଦେଇଛନ୍ତି କହୁନାହାନ୍ତି?
मैं 2000 मसिया किना हेतला एबे से प्रॉपर इंस्ट्रक्शन नहीं केतरा
2024 ଥିଲା 10 ବର୍ଷ ପାଖାପାଖି ହେଲା ନା
नहीं 2024 वर्ष होला सेतବେଳେ आगे खाली चाष जमी थिला एबे सेटा होती सब चाहि हॉटेस्ट एरिया त्रिशूलिया
I tell you
again
you are very ambitious 24 years ହେଲା मिललानी आपको ଆଉ ଲଢିବେ ଆଉ 50 ବର୍ଷ ଲଢିବାର କିଛି
नहीं जगह हमर अछि ଆମ ପୋଜିସନ ଜାଗା ଅଛି ସେଟା କିଛି ଅସୁବିଧା ନାହିଁ
but you can't use it you keep on fighting
ନାଇଁ ଆମେ ୟୁଜ କରୁଛୁ
he in section some interest.
Yes, I will take instruction if there is any possible.
Burden them with interest because the rates have.
Yes, so,
skyrocketed.
10 times if
They
that has
will-
been managed.
They will give you interest for these 24 years and finish it up. They will also be happy.
Yes, so I will take instruction if the matter arises, then I will be sent for mediation. Obliged.
Mediation नहीं, अपन इटी कोई इटी order करी खत्म कर सकते.
ठीक है.
We are the subsequent purchaser. We are the subsequent purchaser. We need a.
Obviously.
I am not even purchased the property. I am only executed an agreement with the recorded owner, legal heir of recorded owner. I have been added as an accused.
Because rates are increasing. Everybody wants it there.
No, my lord.
You know.
I'll show a lordship from the records that I have obtained an encumbrance certificate. There shows the record still.
Shall I send it to mediation? Work it out. Agar he जाऊँ no.
Let them file the reply.
Why reply? Now I am sending.
In his case, notice is to be issued. So other side is to.
I will take instructional lordship thereafter lordship. If there is any possibility of compromise, then
I'm putting it on 21st. Limited instruction on mediation.
21st ମୁଁ ରହିବିନି ଟିକେ next week. Monday
27th ରେ कोंतु limited.
Yes.
Instruction तापर hearing पर है वो किंतु 27th रे only limited.
Yes.
Can
Sir.
it be sent to mediation?
Yes. My lord.
आपण भी
Yes.
आपण भी instruction
आगे.
mediation पठेवा जदि ही जाउची बोले सरला.
आगे. Obliged.
27. Yes.
59. I am appearing for opposite part number 6 to 12.
6 to
12.
Yes.
All are family members. All are family members. 6 to 12, one family.
You want an adjournment? What?
Naturally, I have appeared today. I have to take instruction properly. Well, interim order continue. Continue. Interim order may continue.
6 to 12.
6 to 12.
1 to 1 to 5 you will appear. Nikhil?
1 to 5. Hello.
1 to 5.
5 is Bangladesh Malad. That ASI was arrested Malad by vigilance Malad. Will appear or not?
5? Will you appear 5? 5. Personal ke bikes, ASI.
In his personal capacity, he has been made a party.
This is in his personal. 1 to 4, man.
1 to 4. Nikhil and 6 to 12, sir. And 5, nobody appears for 5. 5 will salary दीजिए किधर हम
5 to notice
right
नहीं फिर कौन है
sufficient document appear open 5 appear nobody
appear
5 that's here intelligent पर entry want to cut
yes sir published
60
टा 500 कोटी अंतु अप्रोच से रिक्वेस्ट करते सीनियर एडवोकेट
one after yes
honor before 22 March 22 March to लेट है गोटे सप्ताह एक्सटेंड करा 53 टा मॉडिफिकेशन नहीं थिला थिला लास्ट वाला थिला honor before 22 March दिन
additional
extension
extension करिया पड़ियो extension time कर दियो तो कहरे केते थिला ऑर्डर टा
पहले ये कहा था
29/2/24
501 थिला देखो he will appear on or before केते थिला
22 March
22 मार्च था ना ताको कोन को पूरी आज तुम पूरी extended the time is further yes okay yes
46
ah
in this case there is a mistake from my part, my lord.
Sorry,
there is a mistake from my part. I have not given the earlier penalty 2019. What that I mentioned 2018.
May what do you want this press matter?
Passing the press matter. Passing the FR along with the DR case and charge sheet because there is a matrimonial dispute. Why you are not coming to the court or the evidence more than the 9 years. Case is pending, instead of order of this court. With that extent, let the notice may issue as against one.
Yes. Issue notice to the
Yes,
opposite party.
And I
Mr. Maharaj case.
am allowed to give the earlier case number, would be that Mr. Rajpuri pointed out. So, I wrote a hitla automation. This honorable direct to dispose of the DR case within 6 months. That are carried out by the trial court team now.
Sir, good memo verify.
Our memo verify.
Okay.
Notice.
Items.
Opposite party, Mr. Maharaj case. And he filed the memo.
Item 7.
70.
Section 7.
7.
Sorry. Lost. The petitioner challenged the order dated 12/12/23 regarding rejection of the petition under section 205 of CRPC.
205.
My lord. Here the petition number 1 is a woman, working woman, working at Puri, HDFC Bank Puri. Petition number 2
Working
as a sales girl, HDFC Bank Puri, HDFC Bank Puri. And petition number 2 is her brother, and 3 is her father. Both are residing at Brahmagiri. Here is my lord. The petitions are accused in one case. Impugned order by the annexure 4. By the annexure running
For last part.
relevant portion 29. Rejected on the ground that the accused number 1 is a newly married woman who is working with HDFC Bank, tied with the Aditya Birla Insurance at Puri. If physical attendance of the accused person is dispensed with the complainant, will in no way be prejudiced. Then the address furnished by the Law and Counsel for the complainant is not far away from the jurisdiction of this court. No proof regarding ill health. This is the ground, my lord. Ill health of petition number 2, brother of the present, my lord. He is suffering. He is suffering chronic obstructive pulmonary disorder, my lord.
Damodar Sahu.
Petition number 2, my lord.
What about other Sahu?
Other is a agricultural laborer, my lord. Chassis.
Then everybody has a problem.
My lord. My lord, the cause of action arose at Puri. The complaint is filed at Bhubaneswar.
I am not.
Distance from
205, insofar as that lady is concerned, I can understand. She newly married, she has gone to somebody's house.
My lord.
And in so far as Damodar is concerned, he is ill. That's what you say.
My lord.
But what is the ground for
The others, my lord, 3 is a farmer, my lord.
Then every farmer, lawyer,
Only
this, that, everybody is doing
but
something.
he is only one.
Have you appeared once also? All 3 of you.
Three, my lord.
All 3 of you have appeared, got the bail.
My lord.
Got the bail.
No, someone. After someone, the petitions are appeared physically.
Physically and
appeared physically. Through their counsel.
Admitted to bail.
My lord. And na bail is na bail is physically appear kori 205 ta ଦେଇଥିଲେ. Physical appear kori 205 ଦେଇଥିଲେ. That 205 was rejected. Both the informant offenses are, my lord, it is a complaint case, my lord. Offenses are
324, 323.
My lord.
324.
Regarding dispute, borrow of some money. Both the informant and the petitioner are known to each other.
I don't settle it.
I
you notice that
am ready, my lord.
exactly small dispute why.
My lord.
Not a very heinous crime or anything other. Or some money dispute.
My lord.
60,000.
60,000.
Pay and
I am.
I don't do pay and finish it up. Unnecessary. Forget
I am ready to.
Forget about the 205. You be ready.
My lord.
Pay back their money and we'll call.
Yes, my lord. Yes, my lord.
Issue notice.
My lord.
Sorted with your issue notice.
My lord, in the meantime, B-double already issued against all the accused persons. B-double he is. B-double.
BW only.
My lord.
Everything is not going to fall. BW. And if the courtship process is issued, then only they'll settle. Otherwise, they'll never settle. Only bailable warrant, no problem. If anything happens in between, you can mention it and I will notice. All them will settle.
Yes, yes, Lordship. Next, Lordship. I say, Lordship.
Must be part of the record.
Yes, yes.
So every document, whatever now he's saying, the inventory list is concerned in the case, it must be with him. The copy दिया से जल्द लिस्ट 20 वर्ष पर वर्तमान को ना मुझे मगान्तु
ସେଇ ପାଖରେ ହିଁ original ଟା ଆସିବ original need to be called for.
Again, even if that is called for, I don't have an objection. So far as C form and C to that register is concerned, 20 years back, he could have obtained an order RTA and submitted it. But when ताको पाई 20 वर्ष से register थिबो नथियो हम तक मगेबु. Only to procrastinate this has been done.
No procrastination, Lordship.
What is the recall? What is the question here?
PW12.
So far as PW12 is concerned, what is the question here? There is no such question here. What sort of question they want to put?
Why have you not properly cross-examined PW?
No, Lordship, that unless that document comes, I cannot confront him. Unless the seizure list comes, I cannot confront him.
That must be part of charge sheet.
No, it is not a part of the charge sheet. Although the search was conducted in connection to this case, the search list and seizure list is not a part of this record. It is a part of another record.
Show me the evidence of PW12.
PW 12 evidence right now I don't have.
That I
But
have to see that.
tomorrow, Lordship, make
Because
it.
see, it is interconnected.
It is
You want
interconnected.
You want to recall PW 12
Lordship.
only to confront some document which are not there on record. So
Yes.
therefore, you want that PW 12 should also come and see those documents should also come so that I can confront.
Yes, yes,
Whether
yes.
relevant questions you have already put to 12.
Yes, that I will show. That I will show, Lordship.
File it.
That I will show, Lordship.
Take it.
It
Take it. We will adjust it. Please file.
yes. I will file the evidence of PW.
What to file? You file the evidence of PW.
PW 12. PW 12 I will file. I have only one prayer, Lordship. The case is fixed to 3rd of April for defense. So if I file, I do not want any stay order. If I file an application for adjournment, that will be allowed. Very common.
ये case, trap case.
Three
Trap
things
or
are
BH.
hello.
In the worst case. In trap case, what is required? Demand acceptance recovery. Cause of action is irrelevant. 31 section 7D. କାମ ନଥିଲେ ବି ଯଦି ନେଇଛି ତାହେଲେ ହବ.
We will come to
ସେ
that.
document ସେ ଯୋଉ
That is the reason I asked. How do you explain?
I got your lordship.
So therefore, he's obviously, but he's entitled to take all defense.
ସେଟା ମୁଁ ସେଇପାଇଁ
Whether it is new to his benefit or not, that's a different story.
ହଁ କିନ୍ତୁ
That is the crux of my defense. That is the crux of my defense.
ଦେବେ ନା.
Defense, whatever he is taking, whether it is new to his benefit or not, that will be
That will be part of the trial.
He moved he's trying to find the evidence of PW
12
on record to substantiate his case. And first, he submits that the defense evidence is fixed to be recorded on
3rd April.
3rd April ତା ପୂର୍ବରୁ ନେଇ ହବ.
ନାଇଁ ମୁଁ ଟିକେ next week ମୋ problem ଅଛି ସେଇ
therefore
April ରେ ରଖନ୍ତୁ.
he would be moving an application seeking adjournment before the court below. If such application is moved, the same may be considered favorable for
a single day. For a single day.
For a single day.
Single day କହିଲେ 4th ରେ posting କରିଦେବେ till
ଏଟା ଏଠି ଆସିଲା ପରେ ହବ ନା.
Owing to the fact that the matter is sub judice before this.
ଆଜ୍ଞା.
Sub judice before. ठीक है.
Lordship. Lordship may further indicate I will also file the evidence of the complainant. That will be relevant for Lordship to judge. Yes. Complainant and PW 12.
File whatever.
That will be better.
Yes. File. PW 12
and the complainant.
Yes.
When the matter will come, Lordship? 2nd week of April.
8 April.
15th. 1/5.
Aye.
Obliged. Yes.
Yeah, may I please, my lord, on behalf of Mr. S.K. Trivedi, one day after, kindly.
You want a adjournment?
Yes.
You have file with you.
Okay.
Do you have file with you?
Yes, sir.
What is this case?
Now, this case is so prayer. It is the therefore most humble prayer that will honorable court may be graciously and pleased allow to interim application and their further proceeding 1 CC number 47 by 57 of
that you are reading so far as IA is concerned. Main petition, main prayer. What are you challenging in that? What is the impugn order? You are not reading.
sorry.
Impugn order is 9/2/2024. What is that? So you must read and come. Anyway, let's give it. Must read and come. You are holding file. Don't come like that. Okay, you must read and come. At least you need to know the facts and what is the case. If the court asks, at least you should be in a position to tell that much. Okay. Okay.
Obliged.
29. 29. Yes. Nobody appearing now. Rejects. 30. Nobody appears. Adjunct to name. 30. 30. Sorry. 31. Nobody appears. Rejects. 31.
Yes, I mean, may I please ask? Dear my lord, petitioner, it's a matrimonial dispute. Seeks to challenge the very initiation of the proceeding at Pipili within the jurisdiction of Puri district on the ground that no cause of action arises here. Background of the case is, my lord, the informant under Annexure 1. I am for the husband and the father-in-law and mother-in-law. All three are made parties here, the petitioners. The marriage was solemnized on 14/12/2021. Annexure 1 is the affair on which the complaint case was lost after almost 2 years of the marriage. The marriage was solemnized on 14/12/2021. She hardly stayed there in matrimonial house at Koraput for 2 months only. Thereafter, she went away along with her relations without informing, on the ground that for eye checkup, she was taken to her parents' house at Pipili. Marriage was solemnized at Pipili within district of Puri district. And subsequently, she had gone to her matrimonial house and stayed there for 2-3 months. And thereafter left 2 months only. 13/2/2022, she left there. Thereafter, my lord, the husband of the informant, I mean petitioner 1, lodged a complaint as Annexure 2 before the IIC police station, alleging that she was taken forcibly by her family members and she was not, she is confined to their family. Though she got married to the informant, she is not coming away. And she had taken 1.5 lakhs cash from the house and went away. Then, my lord, the Annexure 1 was the story made out by the informant.
No, what is
First,
your case?
my case, my lord, no cause of action. Here, allegation under Annexure 1, I am challenging Annexure 1 on the ground that all these cause of action arises at Koraput and Koraput, and no cause of action arises here. So, this magistrate doesn't have the power to adjudicate. Pipili. Magistrate, my lord, on a complaint case, referred this matter to the police for investigation, that to adding 306 as an offence. 306, my lord. You will also can see the manner the magistrate applied it. 306. She is elite. This is the allegation. And this type of...
I'll take instruction, my lord. I'll take instruction, my lord. I'll take instruction, my lord.
And this type of allegation.
Mechanically, orders are being passed.
Exactly, my lord.
Who was that?
Exactly, 306.
Magistrate has not, I mean, police didn't take action because he doesn't have the power, territorial jurisdiction.
Whatever sections are there, IPC, you write down and down.
Exactly, my lord. For that, is there, my lord, and other my lord matters.
I'd say
investigation perhaps.
complete non-application.
Complete non-application, mine. Yes.
Investigation.
There is not the only telephonic call.
Sent to the police station. Police station. Police registered the case and investigated the matter, my lord.
23.
That is, my lord.
18/1/23.
Investigation.
Yes, my lord, I want that.
How can I stay?
No, I am not saying the stay, my lord. The further proceeding, at least I should not be harassed like this.
No.
When police doesn't have the power, how can you?
No court. See, this is the very process. At an issue notice to opposite party number 2. This is one. Mr. Mishra submits that the entire allegation in the FIR indicates that the cause of action indeed has occurred in District Koraput, whereas the complaint has been filed before the court of which court? Pipili.
Pipili, my lord.
Pipili, under 156(3).
156.
And which court is that? Name, tell me the name. Where is that order?
Order is not, I have not annexed, my lord, I have annexed it.
What difficulty you have?
No, my lord, we are not getting.
Order, they show me.
Oh, I have stated in my petition, my lord, it is pending in the court of.
Hey, where is the?
Yes, please,
let
order
us
ta kahin?
see
153 is,
whether he has applied the mind or not, what
Sir, lekha hai
he
to na?
has written.
That order
on
is
basis
required.
of which the order was made.
I'll amend, my lord,
That is the
because
impugn order.
they are staying at
Impugn order.
Thoraput, they are apprehending that. I understand, my
This is all
lord.
right. But your allegation is the magistrate has
Has
not
not
applied the
applied,
mind.
yes.
And where is that order? Whether I see whether mind is applied or mind is not applied. Where is that order?
I'll.
Don't stay. Simply issue notice.
I'm not staying, I'm not paying for stay, my lord.
How
At
will
least,
how will I?
police should not harass these simple persons, my lord. The government
I
servant.
don't know in what circumstances the order is made. Show me the order. Give it like this. I'll read it.
No, yes, ma'am, that is
At
not.
least I should
No,
have that
it is
order.
not with me, my lord. I'm
I
sorry.
pass an interim order without knowing anything.
No. But your lordship, kindly see that from face of it, the FIR itself speaks that 306
FIR
cannot
is all right. FIR is terminating out of a 156(3) order.
156.
Where is that 156(3) order? Show me that.
I pay only one adjournment to get.
I'm adjourning it simply. I'm issue notice and adjourn.
No, they.
Because the investigation is on. So I can't pass a order, no. Simply issue notice, returnable. Okay. 1 week. Put short date, they do. Notice, record run here.
At least no question.
No, I can't. Without the order, I can't. You, and you do one thing. You get that order, move an interim application, I'll give you. I'm adjourning it, move an interim application. That liberty is.
May I pray, my lord, one thing, my lord. Let the petitioner one surrender and go on bail. Cooperate in the investigation, that will be better. Keeping the matter pending here, my lord.
I will be passing a better order if you file the.
Yes, ma'am. Sir, your lordship, ma'am. Obliged.
Simply issue notice to the applicant.
Simply I'm issuing notice. Along with an interim application, you bring all this thing on record. Then it will come up any day.
Only no persecution, percent FIR. Percent FIR. No persecution, percent FIR.
Incomplete petition, I know. Let the help yourself file the complete petition.
Let the IAB lie over, my lord. May we take it up next week.
Give a short date. No, IA will come any day, na? No problem. Main matter, let main matter come whenever. You move the IA, I'll take it up. Come and mention.
Obliged.
Come and mention, I'll take it up. No problem.
On behalf of SK Rao to Anvik after.
Adjourn. 37. Adjourn to me, none of you. 37. Yes. 60. Last one, sir.
May I please your lordship? But in this case, the order of taking cognizance is imposed under Annexure 2.
Yes.
The London magistrate
Notice was issued.
notice issued, interim stay is continuing.
You are appealing.
Appeared, I've already filed my counter, man.
Counter.
Yes.
Ready?
Yes, my lord. I've also filed an IA for vacation of stay, my lord, because there
No,
is.
let me finish.
No, I'm just bringing to the lordship's notice.
What vacation? We'll hear it and finish that.
Whatever your lordship, please.
Yes. Yes.
Here, my lord, the cognizance was taken under section 499 IPC, read section 500 IPC, on the basis of a complaint petition filed by the opposite party. The allegation made in the complaint petition, I have annexed in the annexure 1 is the complaint petition. He stated that I am one of the director of a company, though I have not signed any check, but one complaint case initiated by the petitioner at Delhi under section 138 NI Act, when the Metropolitan Magistrate issued the notice, and after receipt of that notice in Bhubaneswar, his prestige lowered on in the society and petitioner defamed him. This case, and he has suppressed the material facts, and this case is squarely covered as per the Supreme Court judgment dated 2015 Krishna Texports Capital Markets Limited versus Ila Agrawal, where the directors of the company, if a check bounce, all the directors of the company are responsible and they are necessary party to the NI Act. The petitioner is admitted in the complaint petition that he is one of the director of the company, but he has not signed the check which was issued.
But rightly you have implemented. as a proper
Implemented.
party.
I have implemented when the Metropolitan Magistrate issued notice, and he, after receipt of the notice,
They got deformed.
he is defamed. He is a prestige lower down in the society, and he lost everything, mentally upset, everything, lodged a complaint, magistrate took cognizance. Your Lordship may kindly see that judgment. I have that might be available in the record also at the time of it is squarely covered.
बड़े लोगों का वही problem होता है क्या?
Para 13 and 14, 15 are the relevant para. And my lord, this is
This is the known fact that you have rightly implemented. Let us see what are the imputation in the.
But your Lordship may kindly see the annexure 1, the complaint petition itself.
Yes.
My lord.
He
The case 19.
500 or
Yes.
500 petition.
My lord, in my 482 application, I have annexed the complaint petition.
Yes.
Page 20, your Lordship may kindly come.
Let us see the fact.
He admitted that paragraph 1, the complainant company is a private limited company, incorporated into the company, having its corporate so and so. Complainant is one of the director of the PGL Estate Con Private Limited.
Okay.
Thereafter, your Lordship come to the paragraph 4. That when the matter stood that
Along with
the complainant got a notice along with some copies from Hon'Ble Court of Chief Metropolitan Magistrate, District Court, East Delhi, in complaint case number 990/2021, where it has been reflected that the complainant has issued check in favor of accused company, and on the event of degener of that check, accused filed complaint case under section 138 NI Act. It is also further revealed that the complainant have issued check as against the liabilities in respect of the business matter of the accused. On verification of the issuance of check, it is found that the complainant company has issued the check as a security before the accused firm. But the accused, by misutilizing the intention of the check, filed a false case as against the complainant and her other directors. Intention behind it to harass the complainant. On examination of the complaint petition, it is found that the accused have taken plea that on so and so date, the complainant company have issued 2 checks that is so and so 10 lakhs each. It is admitted that check was issued, check was degener. He is the company director, and rightly the petitioner filed a case before the Metropolitan Magistrate Delhi.
Where is the environment insofar as the 500 is concerned?
My lord,
In this
your Lordship kindly come to the para 7.
information. Yeah.
My lord,
It is not out of place to mention that.
para 5, my lord.
Huh?
Para 5.
5.
That it is not out of place to mention here that on dated 8/2/21, accused firm have issued a notice in respect of the checks in question to Kamal Kumar Agrawal. Mr. Kamal Kumar Agrawal has got the notice on his individual capacity, replied the same through his advocate, that so and so. That Kamal Kumar Agrawal absolutely have no fault. Individual capacity, he said, and Kamal Kumar is the managing director. He signed the check in the name and style of PGL Estate. Even on the aforesaid nomenclature, the firms he has not dealt with the accused at any point of time, and even it has also been replied that no notice has been issued by Mr. Kamal Kumar Agrawal. Thereafter, your Lordship may come that para 8, that the complainant, after receiving the summons from the Metropolitan Magistrate, his mental condition is disturbed, and immediately such information circulated in the society of the complainant.
This is the relevant part.
Yes, and everybody used to see the complainant in a very suspicious manner, and friends, relatives, and well-wishers, those who were given in respect of the complainant, also see the complainant
Yes, cognizance is taken in.
Yes,
Cognizance.
Annexure 2 is the cognizance order, magistrate.
And-
I have challenged the cognizance order, but for quashing my lord.
Yes.
My lord,
And complaint petition, that is nothing other.
Proceeding under a due process, under 130. How it defames you under 499?
I completely understand. My lord, may kindly have my counter. My lord, the case is, my lord.
Your only allegation in the complaint is because of the 138 case.
My lord, I'll just now, my lord, I'll say under what circumstances this 138 case. My lord, why I say so? My lord, I'll only have.
Maybe your defense.
No, no, I understand, my lord. I understand your lordship's queries. I am only saying that how it has been filed. My lord, may kindly see the circumstance. My lord, may kindly have annexure A. what has happened here, my lord, my lord, before your lordship takes the document, I'll just say what has happened here. Now, my lord,
But don't say anything which is beyond the pleading in the
I'll
complaint.
not-
Yes.
Because cognizance is taken on the basis of that pleading.
Complaint.
Completely
And
bad.
you confine your argument to that pleading, whether a prima facie case is made out, reading the complaint.
Completely bad.
That's all.
That you may be a fantastic case, but you have not pleaded. And what material was there before the court to take cognizance? Merely because a 138 case is filed against you,
No.
being a director, rightly they have done it. The Supreme Court repeatedly has said that the company as well as the directors are responsible.
Vicarious liabilities to all the directors who are looking after the welfare of the
And
company.
if you are a director, if a 138 case is pending, it's a part of a business.
My lord, may
And
I,
how the prestige has gone.
may I be allowed, my lord? May I get
No,
a chance to
of course you
submit,
are.
my lord? I completely understand. Otherwise, my lord, I'll just leave if my done it.
You
No,
have
my-
full time, because I have a full time.
No, my lord. I'm just only saying I understand your lordship.
will ask me.
My lord, may kindly have page 21.
21 your counter,
No, my lord. Your lordship wants to see what is there in the complaint itself.
21.
Yes, my lord.
Let us see.
My lord, page 21. Now, my lord, may I read it from there? But the accused, by misutilizing the intention of the checks, filed a false case as against the complainant and her other directors' intention behind it to harass. On examination of the complaint petition, is found that accused have taken a plea that on 28/11/2020, my lord, may kindly note the date, and 8/12/2020, complainant company have issued 2 checks amounting to rupees 10 lakhs each, white check number this and this of Canara Bank, Cuttack Road. And in para 8 of that case, it also reveals that the complainant assured on that day, on 28/11/2020, on the accused, both the checks will be honored. Neither on this date, on this date, there was any meeting in between the complainant and the accused. So, question of issuance of check by the complainant does not arise. But the documents, that is the work order, my lord may kindly note that the work order is the essential, issued by the accused to the complainant in respect of certain work, is disclosing that the aforesaid checks were taken as security by the accused for such work order and work. It is also very clearly reflected in the clause number 15E of the work order. So the accused, by taking a false means, not only defame the complainant but also defame the company of the complainant, and by also the goodwill in the market. That it is not out of place to mention. My lord has already seen 5.
Section of the accused is quite deforming.
My lord?
Such accused.
Yeah, but I'm not on 5. My lord may kindly see now 6 and 7. 7, man. That again, my lord may kindly see 6. That even though accused have also replied to his query, but by concealing all those facts, filed a false case before the learned magistrate at New Delhi, intention behind it to defame, that again it is not out of place to mention the accused is
You have fantastic defense in 130.
No, my lord may kindly see 7. My lord,
These are the defenses.
I understand. My lord may kindly have section 7.
Yes.
And he has also involved in different criminal cases bearing number this, filed by the complainant company and in the accused, by remaining in jail custody for a period of 14 days, released on bail, and the matter presently is under adjudication before Honorable Supreme. Another. My lord, may give me just 5 minutes. I'll canvass it. My lord, I'll say on what date he was arrested. When was this 138 file? My lord, may kindly bear with me for 2 minutes. Because, my lord, why I'm saying this? Because your lordship confined me before I started my argument that you will have to confine yourself. I completely bowed down. That is why.
For taking cognizance, what are the materials
I
available?
completely bowed down. I'm duty bound, my lord. That is why I'm taking a lordship to this.
Information and all, the courts are loath in taking.
I completely bowed down. I did my duty, my lord. That is why I'm taking to your complaint first and then I'll show it, my lord. My lord, may kindly see.
Yes.
And the accused, by remaining in jail custody for a period of 14 days, released on bail, and the matter presently is adjudication before Honorable Supreme Court. Another criminal case bearing number 109/2021, Flozen Estate and Developers, and same is also pending before Honorable Supreme Court. Accused cheated the complainant and his company, and also another company for the work mentioned in the work order. Now, my lord, then the company. Now, my lord, may kindly have.
These are the facts, real facts.
I will show, my lord. I'll just take 2 minutes.
My lord, these are the facts. Let me
I
narrate.
did not intervene. No. I did not intervene.
That was finished, immediately finished.
Sir, you are a senior.
These are on
Because the
record.
court asked me.
Please. Please take down.
Now, my lord, may kindly see. Now, my lord, may kindly see just 2-3 things. My lord, may kindly have the work order first. Now, my lord.
In your counter?
My lord, I'll just show your lordship, my lord. Yes, your lordship. That's in my counter as well. My lord, may kindly see 29 of the complaint petition.
Complaint.
Yes, my lord. Annexure 5, page 29. My lord, this is name of the work, construction. My lord says 25/11/2017. My lord has it, my lord?
25 years.
Yes, my lord. My lord, may kindly note, my lord, may turn over the page. This is Annexure 6, page 38. Annexure 6 is the work order. My lord sees work order.
27/11.
I bow down, my lord. My lord, may kindly see page 31, clause number 15.
Clause 15.
Yes, my lord.
Page.
31 of that same work order.
Yes.
My lord, may kindly note page. I'll not take your lordship. 15E. Messrs PGL Eastcon Private Limited has submitted the security checks without date. Rupees 75 lakhs of the contract value of 5 checks. My lord, may kindly note the first 2 check number. 771801, 771802. That is the only 2 checks of 10 lakh rupees each. This was, my lord, given in 2017. When the work order was done without date, it has been mentioned in your work order. Now, the same 2 checks you present in 2021. When do you present it? My lord saw this. This is admitted, my lord. 771801, 771802. Those are the 2. If your lordship wants to correct, now my lord, may kindly have my counter, my lord. Now, my lord, may kindly have it. Now, my lord, first, my lord, may kindly have page 27 of my counter.
27.
Yes, your lordship. My lord, may kindly have that. 771801, 771802.
Yes, 27.
Yes. My lord, may see, this is the return memo for Yes Bank. Now, my lord, may kindly see. Date of return 29 January 2021. My lord, may see the check number 771802. My lord, may kindly turn over the page. 771801. So, my lord, the checks which were given in 2017 as a security, you have done it. My lord, when? My lord, may kindly see date of return is 29. My lord, may see date of presentation. Both were presented on 28 January 2021. Now, my lord, may kindly see the Annexure E, page 25. Why was it presented on that particular day? My lord, may kindly see. My lord,
20.
My lord, page 25, my lord, may see. This is a case diary.
Case diary.
Case diary of First Information Report 113 of 2020. Now, my lord, what do they say? This is Bhubaneswar and Khandagiri.
Case diary in which case?
My lord, that is why I was saying, my lord, the background. My lord, saw, my lord, para 7 when I have said there are multiple cases filed against him, so on and so forth. So, I had filed. So, now, my lord, if my lord gives me 1 minute. What has happened in this case? I approached him. Let us assume for a minute, I approached him. He was doing some work. He was not able to finish those work. I said, I will finish up those work, right? In Calcutta. So we entered into a work order. Work order was given in 2017 saying that, okay, listen, if you're taking over this work, you pay some amount which I've already invested in that for construction. You construct it. Whenever I get payment from my principal, it will be a back-to-back basis. I will pay. Now, my lord, for that, I had given a security. My lord knows. For that, my lord, may kindly have page 20. My lord, may kindly have page 13 for a moment.
You were there in 25. What?
No,
25,
20. My lord, I will just say a background. Page 13, my lord, may kindly see.
13, 1-3.
Yes, 1-3. These are, my lord, on bank transfers, page number 13, Annexure A. My lord, may see the noting of 2411, 2411. 75 lakhs I paid to him to get the work as an advance. 1.5 lakh rupees I paid. Correct?
2411.
2411 minus C, Jyoti Enterprises,
Yes, I thought.
75 lakh, Jyoti Enterprises, 75 lakhs. My lord, he took it. I don't want to get into trouble, your lordship, whether I did the work or did not do the work. I did not get paid. Some amount was left. So I filed a case against him in Khandagiri saying, sir, see, he has cheated me. I had paid him the amount on a basis that he will give me those, when his principal pays him money, he will give me the money. He did not pay. That is that criminal case. Now, my lord, what has happened in this criminal case?
How many cases are going on?
My lord, multiple cases are going on. My lord. Multiple cases. I must confess, my lord. I must fairly submit. Multiple cases. Now, my lord, may see what has happened. In that FIR at page 25, which is a case diary, what has happened? On 21/2021, my lord, may see requisition for police assistance. My lord, may see the last part. Request to SHO Sahadara Police Station, Delhi, to render necessary police assistance for apprehension of accused person, namely Sanjay Agarwal, for the purpose of investigation. As per my request, I, along with other staff, proceeded to the house of the accused in Delhi. Conduct raid on the house of accused. He was absconded from his house to avoid police arrest. Engage reliable sources in the locality to bring. What I want to say, my lord, on 21/2021, in my complaint police went to his house. Now, my lord, 7 days after, he files my old 2017 checks, which are part of your work order. Now you file that and say that this is 138. Now, your lordships are correct. This is also my defense. But my case is, it's such a, my lord, telltale case when your work order.
You answer me one thing.
Yes, your lord.
You said that there are multiple cases.
Yes, my lord.
You have filed couple of cases.
My lord.
He has filed couple of cases.
He has 135, yes.
If filing of cases which are pending
My lord.
Is not a defamation.
My lord.
X case you have filed, no defamation. Y case is filed is defamation.
Yes, my lord.
What is this?
My lord, this is my so what I'm saying is, my lord, prima facie. My lord, my case is a prima facie. In your
So
own.
I think both of you started enjoying litigation.
My lord,
Because if your commercial parlance, you have been doing it and using the courts
my lord,
to settle your score.
My lord, I should refrain from saying that, my lord. I'll not pass any comment.
Because these are commercial transactions. You are both of you are businessmen.
Yes, ma'am.
To take revenge, you file 5 cases. He filed 5 cases. And दोनों का इज्जत इतना खराब हो जाता है.
No, my lord, I am simply saying. Your lordship.
फाइल होगा इज्जत खराब हो गया.
No, my lord.
बाकी केस हुआ तो इज्जत खराब.
No, my lord.
What is it?
No. If your lordship thinks on the face of it, if I have given a 2017.
You see, you are also not.
My lord, 2017.
I'll tell you. I'll suggest you one thing. Don't you people are for your commercial transaction and rivalry, whatever. You are using judicial process.
I have not
both are
started a single case.
Both are
The lordship-
17 check you are.
But
in the face of it.
Let me give the answer. Supreme Court stayed.
Same check
this,
number.
This was suppressed. Honorable Supreme Court stayed the 2 criminal cases initiated by the opposite party against me.
No,
You obtained the work order.
I'm not.
No, my lord, I have annexed this
In so far as
document.
this case is concerned.
Arbitration award, yes. Arbitration award passed against him. That is also
Many cases are
execution
there.
case is pending in Delhi High Court.
It can't be sorted out in this proceeding.
My lord.
Even if making an attempt to sort out all the proceeding is
My
not
lord,
possible,
my lord.
because it is pending in Supreme
My
Court.
lord, I must bring to your lordship notice the Supreme Court also sent on those complaints. It was sent to mediation of the Supreme Court mediation. Mediation failed. So it's back to Supreme Court. My lord, here in this case, I understand your lordship's.
Simply why don't you tender, you tell sorry, I'll close it.
It is not ending.
I'll close it. That will not have an impact on the other case.
My
Simple.
lord, let me explain, my lord. Let me
It's only ego
He
issue.
filed a complaint petition under section 156(3) that was forwarded by relying the Lalita Kumari case to the Khandagiri PS. He lodged. On his request, work order was issued. That I have annexed the
You also
document.
file 500 now.
My lord,
You also file 500.
no. I have not filed, my lord.
Because you cannot prove that you have
I am only defending.
deliberately done
I am
something
only
wrong.
defaming. He has it. I am a my lord, innocent person. He is saying he is a pan-India contractor of CPW, and he requested his sister concern was initially awarded the work. He failed, did not execute. Thereafter, he has written a request.
Show me the cognizance order.
My lord,
Show me the cognizance.
Annexure 2, your lordship may
Cognizance order passed.
Cognizance order is Annexure 2, page 25, my lord. Your lordship may kindly.
Wasting of court's time, nothing else.
25, my lord, page 25.
Case is there 200 complaints also.
Peruse the complaint petition, initial statement of the complainant and other material.
What are the initial statement and what are the material, no material.
No material.
The work order was telltale, my lord. That is
no material.
Initial order, so initial statement.
Initial statement is the same
I'll
thing.
have to see whether.
Well, it's the same thing,
500 is
whatever
made
he
out
has
of.
stated in the complaint petition, same thing.
Where is
They have
that?
not filed it, my
That
lord.
I have not filed, my lord.
You
Because
people-
it is, my lord, only the cause of action arose in this case after receipt of the notice from the Metropolitan Magistrate. And whether the check was issued or not, whether it
All
is
this
a,
is a
he
defense.
may raise this in the
My
trial.
lord, my lord,
Why
just-
he has not disclosed all
Whether
this?
500 is made out or
Yeah.
not.
My lord, just for your information.
How will you make up 500? You tell me.
Well, my lord, that is what my case is, my lord. In a security checks which are mentioned in your work order of 2017, mentioned clearly that these are undated. you present those 7 days after the police have gone and you are absconding.
That is the pure and simple defense in 138 case.
I completely bought it.
How
That
it
is,
is defamation, I don't understand.
my lord, if a case is filed against
A
me,
false case is filed against you.
my lord,
Will lead to a defamation. You first fall, you have to then, I'll have to keep it, I'll have to stay this proceeding till 138 is decided.
if my lord, the things that my lord,
Because unless 138 court says that it is a false case, I can't presume it to be a false case.
I bought it.
And you can only be deformed if the 138 court says that it was a completely false case.
My lord, I'll leave it alone. My lord, it's a telltale case. My lord, I'll not argue it. My lord has already seen a 2017 work
Then I have
order.
to presume that 138 case is a false case.
But I'm not.
Then only I can say that yes, it was
No,
deformed.
no,
Deformation is made out because it was a false case.
My lord, clearly in that complaint, if your lordship sees that complaint, they have not filed it. My lord, I've got a copy of the complaint. In that complaint, they have said nothing. They have said nothing.
138. I need not read.
No, I know, but that is what they have said. They are, our entire case is in the 138.
I need to read two things. I need not go to anything. One is the complaint under 500.
Yes, sir.
And the preliminary statement.
Let them produce the preliminary statement.
Give the preliminary statement. Initial statement. Obviously, that these are the two things on the basis of which cognizance is taken. You and the all these things are not irrelevant for me.
Correct.
Whether any case is made out under 500 or not, that has to be seen. As simple as that.
Lordship, please.
Why I get it?
Case is made out or not, that is one part, my lord. Supposing I am not on that case should be quashed on the ground because of NI Act.
You say cognizance order is wrong.
Yes.
Yes, NI Act case was initiated and notice, after receipt of notice, he became defaming the society. Whether he is a necessary party to the NI Act case or not, that is first to be decided. Whatever initial state may be. And my lord, the work order, your lordship will kindly go through it. That so far as the
whether he is necessary party or not, I can't comment in this.
No, that the Supreme Court judgment is.
I can't comment because that will prejudice the 138 case.
138 case, he may be
I
in the good defense.
I can't speak a single word about 138.
Yes,
because
that's
it will prejudice the pending case.
Yes.
I can't do it. I'll have to see whether any sufficient material is there.
I will produce the certified copy. I will produce the certified copy. I will obtain that certified copy initial statement.
And will also assist in this.
But yes, counter is completely.
That is also there. He will also assist being the.
Yes.
But the counter it is something else. The complaint petition is something else.
But that I need not go.
No. That is the case. And I have annexed all the documents. Work order, check. I have also annexed the check also.
But my prima facie view is merely filing a false case, according to you. False or right. Merely filing a 138 case will not tend amounting to information.
I would.
Because if you would have not a party in the sense that you would not have a director of the company, check which company has issued check, you may have a case.
I completely.
But you are a director, company has issued a check, though it is 2017 check, presented in 2022, maybe it is for security, whatever. All these things are pure and simple defense. You may succeed in 130. But how come you make out a case under 500?
My lord, my humble submission is, if such a...
And all these things, what are you saying? All are valid defenses. You can raise all these things before the 138.
No, I completely bowed down. I'll not argue with your lordship. I mean, I'll stay within my entire case is, my lord, if your lordships in your constitutional power, if you looks at such a case where it's a telltale case, it's a complete abuse of the process. I understand your lordship are saying that if it's a complete abuse of process, you go and defend yourself in 138. I completely bow down. Now, my lord, my right that if
you have a right to proceed for malicious prosecution.
No, that is what I'm saying. Malicious prosecution is after 138.
Every malicious prosecution is not defamation.
No,
you know that.
No, I completely agree. I completely agree. But my lord, what is happening in this case is there is two things clearly. For he sits over those checks which have been given.
Your right. I will reserve your right to prosecute him even for malicious prosecution if you get acquitted in 138.
Well, that's a part. My lord may see the records, my lord, which under which cognizance has been taken. If your lordship feels, your lordship can do it afterwards. My lord, your lordship can do it, my lord.
See, the criminal liability is 500. Civil liability is damages.
Yes, sir.
Damages.
Your Lordship.
It is always open for you to file a damage suit.
Either, yes, ma'am. I bow down.
Whether 500 is made out or not made out, irrespective of that, you can very well file a damage suit.
I bow down.
He is wrongly prosecuting me or false case,
Your
whatever.
Lordship, please. Yes, yes, Your
That is
Lordship.
also there.
Absolutely.
So I can keep that open.
I bow down. My Lord, if
One more submission. Another director, Preeti Agrawal, the sister of the present opposition, initiated a defamation suit in the Bhubaneswar. I filed an
Rightly so.
My lord, because after receipt of the notice, he defamed the society. She was also.
Rightly, see, civil proceeding,
My lord,
even he can draw it.
Order 7, Rule 11 application was filed.
711,
The learned
no cause of
the
action.
learned subject rejected the claim. Defamation suit. This is the second attempt.
All arising out of a ecosystem.
Yes, your lordship may kindly appreciate
That's
that.
what
That also.
I said
That also
you
I
people
have.
are using the court.
I am not using. I am.
My Lord, if
Well, I have
only
to
clarification is ego, must be ego to a certain extent, but also the fact that we are financially burdened. No, my Lord, no, my Lord, because we are financially burdened. We had already, as I showed, my Lord, we had paid around 1.94 crores.
What happened to the burden on the courts?
My Lord, I'm here to, my Lord, I am only enforcing my
You
right.
say you false case, he says false case, but the entire proceedings are false.
No, my Lord, I'm not on that. No,
And the courts are here to decide.
no, my Lord,
false cases.
with all due respect, my Lord, it's not false. My Lord, 1.94 crores is on record. My Lord, I'm saying this. 1.94 crore records, it's on record that I have given him. I am saying that I've received 1.36. That is why I filed a complaint. My only reason of filing a cheating case is that, listen, I paid with a bona fide belief that he will give me the money when he gets it. He's not given me, he's absconded. On that basis, the Khandagiri police station went to nab him, my Lord. It is not an ego trip. My Lord,
Paying
this is
money
a
to the
clear...
police in a complaint case and
No, my Lord, I don't know if the state will accept such a submission
yes,
saying that money being given to police.
I have no.
I don't know if such a statement.
State is also being used.
I have no
in your
objection, my lord.
simplified.
My
No,
lord,
no, no, that's to assist your lordship. That's to assisting your lordship.
Order may be extended. my lord.
Anything order will continue, you filing.
My lord,
Give a copy to.
I'll give it to writer. Good.